May I have your lordship's leave to mention a matter? Well, the matter is appearing as item number 21 in your lordship's list today. Well,
22.
21. Well, on an earlier
Commercial.
yes, my lord. On an earlier occasion, your lordships were pleased to, my lord, dispose of the stay application and, my lord, set down the appeal for hearing. The appeal is appearing today in the list. But, my lord, on that day, my lord, an undertaking was given to court that pending the hearing of appeal, my lord, no steps would be taken to, my lord, disturb
Alok
the stay.
Saraf.
Yes. Now, my lord, that is not a part of the order, but that is, my lord, your lordships were pleased to observe that, my lord, this will be evident. This is already on the YouTube recording. My lord, there was an undertaking given. Now, my lord, we have been served with a notice of disconnection of electricity for due stemming back to 2018. My lord, that is, my lord, what concerns us today, my lord, because the appeal will be, my lord, partially frustrated if that is, my lord, the situation.
So you want an early hearing?
Well,
Have you filed
early
any
hearing,
application?
in the meantime, I would expect my lord.
Have you filed?
No separate application has been filed. They have only
No,
given
no.
us the mentioning notice.
We had, that is right.
And
My lord, I have not filed a separate application because, my lord, the YouTube recording will show that my learned friends had undertaking to court that, my lord, they will not disturb the status quo pending the hearing of the appeal.
Yes.
but this is not a part of the dispute, lordship.
It is a part of the
This-
same premises.
If they are
Is it correct that while we were disposing of the stay application filed in this appeal, an undertaking was orally given to us that pending disposal of the appeal, no coercive step will be taken.
yes,
If
lordship.
that is correct, then why this notice?
They are consuming the electricity and we are paying for it. We said that we are not going to pay it anymore. So if the electricity line has been
My lord, it's from
any steps have been
2018.
taken, it will be taken by the CAC. We are not going
No, my
to
lord, it is
CAC is a party.
18.
CAC. is
Well,
not
it is-
party. That is what I'm
Well, the
saying.
disconnection notice has been given by my learned friends,
Yes,
not by
because
CAC.
it's coming to us and we are paying for it.
Whatever the reason is, if your undertaking was not to take any steps against them, wouldn't that be a breach of the undertaking? Whatever the reason is.
Lordship, I sincerely bow down before Lordship because this is not according to
So
us.
please advise your client not to do, because do not take steps. Let this be. I think you should file an application, a 2-page application.
Very well, we'll do that.
But in the meantime, do not take steps.
Lordship, because in
You, Ms. Paja, you please advise your client. See, they need good advice. Do
Yes.
that.
I sincerely
If the undertaking has been given, then it has to be honored.
yes,
Right.
I sincerely bow
In the
down.
meantime, you file an
I will
application
file
today.
an application, but my lord, your lordships has also been pleased to indicate that the matter will be within the first 3 matters of the list.
Did we say so?
But my lord, I know, my lord, your lordship's
No,
difficulty.
first 3 from the bottom, possibly. Just see, it is there.
That's
Since
right.
Lordship, it is not in the first 3 matters, Lordship, it is appearing as item 21, Lordship. Lordship, let it be
I
come
will,
accordingly.
my lord, I leave it to your,
This
my
against
lord, your
come
lordship's convenience. No, my lord, it is your lordship's convenience that will have to be, my lord, ultimately.
You
seen.
file an application, give the number. The application and the appeal both will be listed under the heading new application,
I'm grateful.
and we'll take it up
All
from
the
there.
more. Very grateful. Very
Your
grateful.
Lordship, I'm led by my senior, Mr. Pradyumna Sinha, who will be mentioning virtually.
My lord, may I have your lordship's leave to mention one testamentary appeal for inclusion
Yes.
in the list?
Inclusion, yes. Give the particulars.
Yes. My lord, may it appear any day subject to your lordship's convenience?
Yes, it will appear tomorrow itself.
No, my lord, after 10.
Then why did you say any day?
My lord, after 10. And I'm going to request that. After 10.
10th.
My lord, 8 to 10, I have an arbitration, that is why I
11th.
My lord, much obliged. Much obliged.
Well, may I be permitted to seek a leave? My lord, this is a very urgent matter. Your lordship directed to demolish the construction.
What do you want?
My lord, I want a leave, my lord.
To do what?
Proceed on Tuesday or Thursday, my lord. Wednesday or Thursday, my lord.
Leave to proceed on Wednesday.
Yes, my lord.
Proceed where? Proceed against whom?
My lord, in this matter, my lord, your lordship proceed.
You want to file an appeal without certified copy?
No, my lord, it's a recalling applications, my lord. Your lordship directed to demolish the structure within a period of months, my lord. 17 July order was.
Recalling of this bench order?
Yes, my lord.
File it.
I want to move it on, my lord.
Now you want to move it?
No, my lord, within Thursday, my lord.
So file it first, sir. Survey it.
Yes, my lord.
Mean ki original side?
No, appellate side, my lord.
কি আশ্চর্য, অ্যাপিলেট সাইড ডাকা হয়েছে কি? বড় হড়বড় করে। ওটা নিয়ে নাও, দিয়ে দাও। কি নাম্বার হয়েছে?
No. Let's leave, my lord.
কিছুই হয়নি, লিভ দিয়ে দাও, serve on the other side.
Yes.
But, with leave of my lord, Justice Chattopadhyay, may I have permitted to mention one matter, my lord, for modification of your lordship's order, sitting with Justice Apurva Sinha Roy, my lord. I have served already, my lord.
Item number 1 is my appeal, my lord. I mean, led by Mr. Rudhuman Bhattacharya. He's in some difficulty today. I was only seeking for not today, my lord. He's in some difficulty today, I understand.
We said yes.
Very well, not
one issue, my lord. There may be an issue of limitation.
Let him come back.
They haven't even
Yes,
filed
that issue will remain on the next day also.
very well, my lord. Not today. sir.
Not today.
Not today. Not today, Judge. Not today. Grateful. Great.
Item number 2. I am supposed to respond on the last.
Pass over.
You are supposed to file the affidavit and reply today.
I'm paying for Passover, my lord.
Number 3.
But my appeal.
Paying for the respondent. There is no scope for interim order. There are 2 applications, one for stay of recalling of that order 9/2/30, and the other one is the condonation of.
That section 5 application is there, delay of 22 days. I'd be seeking the condemnation of that.
Mr. Dey, let the delay application be.
Something to say. I want to file affidavit. There are a lot of mistakes and.
But I'm being led by Mr. Bordhan.
The condonation application. Kindly allow me to file.
22 days delay.
If he insists, what can be done?
We can't stand in the.
Litigant has a. Well, filed 3 applications, 1 appeal and application on all the time with the condonation application. First time was 355 days. Second one, order 9 was 605 days. Now that also dismissed. Now it is on 24 days.
22.
Maybe, but this is a different matter, Mr. The only thing that 22 days, if you insist, we'll grant you time.
A lot of misstatement is also not properly verified.
Hey, which one is the section 5?
1. Can 1 is GA1 is the section 5 and GA2 would be a stay application.
3 weeks kindly my client at Siliguri kindly give us 3 weeks.
No.
Well, next week my client will not be available, so
that is your client's problem, Mr. Dey. 3 weeks is unreasonable for a section 5 opposition.
What I'm submitting that both the applicants give direction in both the matters, so that both the matters can be taken up.
Yes, we'll give direction both the matters. GA-COM 1 of 2025 is an application for condonation of delay of 22 days in presenting this appeal.
But it is 24 days. According to my service copy, it is 24 days.
Stop. GA-COM 2 of 2025 is a stay application. Stop. Learned advocate for the paragraph. Karo. Respondents, you represent all the respondents.
And I'm pretty only the plaintiff respondent, the only plaintiff respondent.
Learned advocate for the. Have you served everybody, Mr.
No. Served everyone. Oh, no, we have served the respondent number 1, 2, 3, 4, all of them.
No, then why?
Service.
Where's your affidavit of service?
Where's the affidavit of service?
It was there.
This is not the motion. I'll just take a moment of my lord. What is this? Served kara koto hoyeche. Has it been served on all?
There are other 3 respondents.
No, not served on all.
No, then serve and come back. Serve and come. Kichu likhte hobe na. Acha lekho. Learned advocate for the appellant says that
fine.
Service on all the respondents is not complete. Paragraph, let service be effected on all the respondents and affidavit of
They are
service,
dependent respondents, my lord.
whatever it is, be filed in court on the next date. When shall we keep it?
No, any day after, my lord, the expiry of the time of the period, my lord.
After expiry of?
Of the period, my lord, which they are taking for filing affidavit.
No, we are not giving direction today because your service is not complete.
3 days. 7 days.
Bangladesh service.
My lord, service at Bangladesh, my lord. So after a fortnight, my lord.
Very well. As requested.
And we can serve also by email, my lord.
As requested, comma, let this matter be listed after a fortnight. Date ta diye dao jete.
I'm grateful. My lord.
ওই ডিরেকশনটা দেবে না, affidavit কিছু লিখবে না, খালি এটা, হ্যাঁ, আগেরটা কেটে দাও।
সার্ভিসটা করলি না কেন? I'm grateful, my lord.
For hearing item number 4 and 5. And I am comfortable. I'm for the degree holder. Respond. Degree holder respond.
Setia oil. Did my lord have occasion to deal with this matter sitting singly?
Not this matter.
This is not
Different
related with the single bench
matter.
matter.
Agriculture matter, not this.
That is separate.
That's totally separate. Worship, I'm led by Justice, I'm led by Mr. Sakhar Sen, and not in court. Not in court today. So just 1 day's accommodation.
Mr. Ghosh?
Maybe he finishes, will answer.
No, don't do that.
No, I never go on. I'm so sorry.
Only
the day after tomorrow.
Day after, you want it day after tomorrow?
Yes.
Learned advocate for the respondents. You appear for all the respondents, Mr. Surana?
Two also. No. Only respondent one.
Learned advocate for the respondent number 1 seeks accommodation, paragraph, as suggested by Mr. Ghosh, learned senior counsel, appearing for the appellant, let these 4 or 5 action these matters be listed again on Porshudin date, retaining its position.
Mine. Sorry, man.
Now, retaining its position at the same position. At the same position.
Sorry for asking.
Why? No problem. The weather is beautiful outside. Go and enjoy.
Item number 6.
I'm in rejoinder, my lord, only on that short point which your lordship had indicated. Your lordship kindly takes your lordship's.
What was the point we indicated?
Well, it's once if leave has been granted.
Yes. Change of circumstance or accepting fraud and
whether it can be done on any other ground.
3 points.
No, my lord, the other point which was indicated, which my lord kindly takes the order first.
Lordship, go.
Before you start, I would like to know, we would like to know, particularly myself, is one Mr. Shushen Mitro assisting you properly? Good.
If your lordship kindly takes your lordship's order.
Order to the order.
Here, June 25th.
Yes, Mr.
Now, if your lordships have gone through the order, my lord, we'll see one thing, my lord. First of all, this issue, what your lordship had asked me to address, but it's already been answered by in a judgment passed by this honorable court by a single bench, my lord. That order is there. I'll place that also, and I will show the Supreme Court order also, which deals with this aspect. My lord, to answer this, your lordship will have to take one thing into consideration, that this is a point, my lord, of demurrer. Now that has been conclusively held, that if someone doesn't comply with 12A, well, the consequences is rejection of plaint under Order 7, Rule 11, Subclause D. So, my lord, taking that into consideration, my lord, the foundational pleadings which are required to be there in the plaint, my lord, that is of prime importance. If pleadings are only absent, my lord, in that case, it becomes a jurisdictional error. And in that case, my lord, under Order 7, Rule 11, my lord, a plaint can very well be rejected. Because, my lord, partial automation as well as, my lord, the last judgment which I cited, Dhanbad Fuels, both say so. My lord, foundational pleadings have to be there. My lord, this falsity and deception, the two other grounds, my lord, this is an addition which, my lord, has been introduced by the judgments of the Honorable Supreme Court. My lord, falsity and deception with regard to, my lord, urgency. Or, my lord, some sort of an artificial urgency is shown, my lord, where in reality there is no urgency. My lord, that also, in my respectful submission, would be a falsity in urgency, an artificial urgency. Now, my lords, there has been, my lord, if your lordship takes as an example, there are several matters, my lord, where plaints are admitted. Then, my lord, the defendant comes up with an application under Order 7, Rule 11, playing for rejection of plaint. My lord, in that conspectus, your lordship goes through the plaint and sees whether, my lord, the pleadings are there or not, whether cause of action is there or not, and then your lordship rejects the plaint. This is that. My lord, it's a right, my lord, which, my lord, the statute has provided, my lord, to a defendant to take this up. Now, my lord, apropos this, my lord, I had, my lord, in fact, in the compilation only, there are two judgments which addresses what your lordships had raised, my lord, on the last occasion. My lord, kindly first takes the partial automation case itself. That addresses this issue to a certain extent. The relevant portion is page 53 of the compilation, my lord, which I had, my lord. Right. Lordship takes page 53 and comes to para 94.3, my lord. This is like a summation of the scheme of the act. And, my lord, what is permitted basically. My lord, kindly sees 94.3. Order 7, Rule 11 does not provide that the court is to discharge its duty of rejecting the plaint only on an application. Order 7, Rule 11 is in fact silent about any such requirement. Since summons is to be issued in a duly instituted suit, in a case where the plaint is barred under Order 7, Rule 11D, the stage begins at that time when the court can reject the plaint under Order 7, Rule 11. Then, my lord, no doubt it would take a clear case where the court is satisfied. The court has to hear the plaintiff before it invokes its power, besides giving reasons under Order 7, Rule 12. In a clear case, kindly sees, where on allegation in the suit, it is found that the suit is barred by any law, as would be the case where the plaintiff in a suit under the Act does not plead the circumstances. To take his case out of the requirement of Section 12A, the plaint should be rejected without issuing summons. Undoubtedly, on issuing summons, it will be open to the defendant to make an application as well under Order 7, Rule 11. So, my lord, foundational pleadings, my lord, is the first requirement in my respectful submission. Pleadings has to be there. Now, your lordship would have to see, my lord, in this case, my lord, the impugned order records that the pleadings are not there. The requirement, the requisite pleadings for, my lord, dispensation of 12A is absent in this case. Because there is no urgency. My lord, the pleadings are, it's a trademark suit, recurring cause of action. Then, my lord, the other pleading is that it's a continuous cause of action, and therefore this should not be, my lord. There is no, and because the parties are litigating in, my lord, the trademark registry with regard to the trademark, registration of trademark.
Rectification.
Therefore, it will be an idle formality. My lord, this is the pleading. In that conspectus, your lordship has to test this. Because this is in the nature of a demurrer.
Which is the other case?
Now, my lords, now, if your lordship takes in the compilation, there is a judgment, proactive shipping. My lord, page 68 of the compilation.
Yes.
My lord, that exactly addresses this issue. And my lord, this is considered all the cases right up to Yamini Manohar. Only the last case, my lord, Dhanbad Fuels is not being considered. Because at that point of time, it was not there. Just 1 second. It starts at, my lord, page 68.
Yes.
Now, my lords, kindly takes, my lord, the relevant portion, paragraph 8. The issues which hence fall for decision are headlined below. The answers to the issues form part of the discussion. Can the dispensation granted under Section 12A of the Commercial Courts Act be subsequently revoked? If yes, can the suit be dismissed under Order 7, Rule 11 of the Code of Civil Procedure 1908? Well, then kindly sees, 12A is quoted. Then paragraph 10, Section 12A makes two things clear. A suit which does not contemplate urgent relief under provisions of the 2015 Act cannot be instituted unless the plaintiff first opts for pre-institution mediation before instituting the suit. The suit can, however, be instituted if the plaintiff obtains dispensation of the mandate of Section 12A at the time of institution of the suit. But paragraph 11, in other words, the plaintiff must establish, and the court satisfied on such showing, that the plaintiff requires urgent interim relief, and the urgency would be frustrated if the plaintiff is relegated to mediation instead of pursuing its urgent interim relief in the suit. Now, let's kindly see thereafter, paragraph 14, the heading, who decides contemplation for urgent relief? Since the carriage of proceedings is with the plaintiff, the onus of proving that there is a need, there is indeed a case for urgent interim relief, rests squarely on and must be discharged by the plaintiff. How can the plaintiff do this? That's paragraph 15. By way of pleadings in the plaint. After all, the plaint forms the substratum of the suit, consisting of the lineup of parties, the cause of action, and the reliefs claimed. The case for urgent interim relief must be stated and spelled out in the pleadings in the plaint. Well, just pausing here for a moment. If your lordship takes even the Code of Civil Procedure, Order 7, Rule 1, for a minute.
Raju Bakau character.
Time takes Order 7, Rule 1. Particulars to be contained in the plaint. The plaint shall contain the following particulars. Kindly takes F. The fact showing that the court has jurisdiction. Here, in my respectful submission, because of the embargo which is there, my lord, pleading urgency would have to be there to show that the court has jurisdiction. Otherwise, the first option will be to exercise the option of mediation. So this is something which is required to be pleaded. In a case, my lord, where the pleadings are only absent, my lord, the question of, my lord, a leave being granted, my lord, in that case, my lord, an Order 7, Rule 11 would be entertained in my respectful submission, and the consequences would have to be followed. Now, let's kindly see thereafter in this judgment. By way of pleadings in the plaint, after all, the plaint forms the substratum of the suit, consisting of the lineup of parties, the cause of action, and the relief claimed. The case for urgent interim relief must be stated and spelled out in the pleadings in the suit. Then, my lord, kindly see, this is also extremely important. Is the plaintiff the only discharger of the onus? The court receiving the plaint and considering grant of leave for dispensation of the requirement under section 12A of the Commercial Courts Act is also clothed with the power to decide whether the suit contemplates urgent interim relief at the point of institution. In other words, the contemplation under section 12A is not the sole domain of the plaintiff, but a multi-decision domain where the court also plays its part in deciding whether the suit contemplates urgent interim relief, and consequent to such decision, whether the plaintiff should be granted leave to institute the suit without exhausting the pre-institution mediation option. Then, my lord, Yamini Manohar is quoted, relied on. Then kindly sees paragraph 17. The owner shifts to the defendant subsequently to establish. This is the changed circumstances referred to in your lordship's order. Thus, owner shifts to the defendant subsequently to establish that the suit did not contemplate urgent interim relief at the time of institution. The court will then examine the case brought by the defendant in considering whether the dispensation of the mandate under 12A was wrongly granted. It is also relevant to state that grant or refusal of relief is not relevant. So, my lord, whatever be the merits, that is irrelevant, my lord, so far as my lord 12A is concerned. It's what is important is to plead that urgency. Then your lordship sees the court's finding on urgency is, however, of paramount importance. This is precisely where the second order dated 19/10/23 comes to the fore. Well, then kindly comes to straight away to paragraph 25. Section 12A of the Commercial Courts Act and clause 12 of the letters patent. Clause 12 of the letters patent 1865 authorizes the Chartered High Court in exercise of its ordinary original civil jurisdiction to receive, try and determine suits of every description if the cause of action has arisen either wholly or in part within the local limit of the ordinary original jurisdiction of the said High Court. The plaintiff is required to obtain leave in respect of the part of cause of action. The defendant can subsequently pray for revocation of that leave on the ground that no part of the cause of action has arisen within the territorial jurisdiction of the court. Well, here your lordship would have to see then the pleadings as there, what is there in the plaint, and on that basis decided. The court, on weighing the competing cases of the plaintiff and the defendant, is empowered either to revoke the leave or reject the defendant's application for revocation. The power of High Court to grant dispensation of the requirement under Section 12A of the Commercial Courts Act 2015 is on a similar footing and conferred by the said Act. The High Court is hence entitled to revoke the dispensation granted under Section 12A. The power to revoke the dispensation granted under 12A can be made even suo motu, without even being tethered to an application made by the defendant in that regard. Well, kindly see thereafter. Can Order 7, Rule 11 of the Civil Procedure Code 1908 be pressed into service on a subsequent no urgency finding of the court? Order 7, Rule 11 of the Civil Procedure Code 1908 provides for rejection of the plaint and dismissal of the suit on several grounds, including the suit is barred by law. Therefore, if the court comes to a specific and subsequent finding, either suo motu or on an application made by the defendant that the suit did not contemplate urgent interim relief at the time of institution, the court is entitled to dismiss the suit on Order 7, Rule 11D, barred by law. That is, the suit contravened the mandate of Section 12A of the Commercial Courts Act. Then partial automation is relied on.
There was no appeal from this order.
No, my lord. Then kindly see 29, my lord. To repeat, institution of a suit which does not contemplate urgent relief without exhausting pre-institution mediation under Section 12A of the Commercial Courts Act falls under the statutory bar under Order 7, Rule 11, Subclause D of the CPC. The statutory bar would hold good even if established at a stage subsequent to the institution of the suit. The court can hence treat the contravention within the fold of Order 7, Rule 11D. Then, Malaj, paragraph 32. Malaj, the facts are quoted. Then what happened in the returnable date?
Those may not be relevant.
And the summation, Malaj, thereafter at paragraph 38. Malaj, 40 is important. The plaintiff's argument that contemplation of urgent interim relief may revive post-institution of the suit even at the stage is without statutory basis. The word used in Section 12A makes it clear that contemplation of urgency begins and ends at the point of institution. That is material point of time when the contemplation must fructify into a proved and pleaded case for urgent interim relief. Hence, allowing the suit to remain in the records despite an absence of urgency on the contingency that urgency may arise at a later point of time is patently contrary to the mandate of 12A. 41. Moreover, the words urgent interim relief by its very definition means relief which the plaintiff seeks at the interlocutory interim stage and one that cannot wait for a later adjudication on affidavits or at the time of trial. It hence stands for two reasons that the plaintiff would be under an obligation to explore mediation as an alternative dispute redressal mechanism before institution of a suit where the plaintiff does not need such urgent interim relief. Leave for dispensation of the mandate of Section 12A would hence be necessary where the plaintiff cannot afford in terms of time, to exhaust the remedy of mediation and only thereafter institute the suit. Section 12A was inserted, my lord, then partial automation, my lord, that it's not purely procedural and that it is mandatory and it must be visited with rejection of claim.
Did this decision deal with Srishti? No.
No, this is a pre-Srishti case.
This is pre-Srishti.
And Gabriel is quoted. Learned single judge says since Gabriel doesn't deal with Jamini Monohar and or
Anyway, you take your seat.
So, my lord, this considers Yamini Manohar. This considers partial automation. Partial automation has been held by the Honorable Supreme Court in Dhanbad Fuels to be laying down the correct proposition of law. My lord, apart from this, my lord, one judgment which I want to rely on.
Last one.
Yes, my lord. On, my lord, just giving examples on the fact that, my lord, when can leave be revoked? And, my lord, what is required? My lord, what is very important is pleadings have to be there. My lord, if any order is passed, deholds the pleadings, my lord, it would mean, my lord, it's a jurisdictional error. My lord, this is, my lord, 2018. My lord, 2018, 11 SCC 652. Para 26. Para 26, if your lordship takes placetum right above placetum D, it is settled principle of law that the parties to the suit cannot travel beyond the pleadings. So also the court cannot record any finding on the issues which are not part of pleadings. In other words, the court has to record the findings only on the issues which are part of the pleadings on which the parties are contesting the case. Any finding recorded on issue deholds the pleadings is without jurisdiction. So, my lord, in this case, if the pleadings are not there, my lord, and if any leave has been granted, my lord, it goes to the very root of the matter in my respectful submission. It's a jurisdictional error And my lord, in an Order 7 Rule 11 application, my lord, a court has the right, my lord, to see the pleadings and decide, my lord, whether the case has been made out or not, and my lord, revoke a leave. My lord, take for example, my lord, a suit being barred by limitation. My lord, your lordship knows that it is a duty cast on the court to see, my lord, dehodes an application. My lord, many a time a plaint is admitted, but my lord, on an Order 7 Rule 11 application, when the defendant brings those facts before the court, and the court is, my lord, satisfied or convinced that it is ex facie barred by limitation because of the pleadings which are there, or because of absence of pleadings, your lordship always exercises the jurisdiction under Order 7 Rule 11. Now, my lord, there is also your lordship's judgment, my lord, sitting singly, while rejecting, my lord, by revoking a leave under clause 12.
Must be entirely erroneous.
Well, this is well, it's 2015 SCC Online Calcutta 4437. But this is obviously on, my lord, clause 12.
Yes.
Well, here also, your lordships, my lord, leave was granted. Your lordships went through the facts as pleaded, and then your lordships, my lord, revoked the leave. So your lordship has to test this.
Any particular paragraph you want
Yes,
to
ma'am. The facts were considered, your lordship sees, my lord, it's just, my lord, only for that proposition, my lord, that the facts were taken into consideration as was pleaded, and then your lordships comes to the finding that clause 12 should be revoked. My lord, there are also other decisions of the High Court, my lord, which I am not relying on the same, because your lordship has considered, my lord, the Perrin decision of 1949, my lord, in this, my lord.
That is all, Mr. Rajadri?
Yes, my lord. Now, my lord, the only thing, my lord, now, apropos this, your lordship sees the impugned order once. My lord, only 2 paragraphs of the impugned order. The internal page, my lord, page 20 of the memo of appeal, my lord, and internal page 8 of the order. My lord, in the facts of the case, the plaintiff has admitted that they had knowledge of the impugned product since January 2024. Having admitted this factual position, it was incumbent on the plaintiff to provide grounds or justify as to why they had waited for 9 months before instituting the suit and obtaining dispensation under 12A of the Act. The plaintiff is wholly silent on this aspect of the matter. The omnibus averment in the plaint is that, being a suit pertaining to intellectual property rights, the cause of action is continuous and recurring, and hence the need for urgent interim reliefs. There is no quarrel with the proposition that the cause of action in a suit for infringement and passing off is recurring in nature. Nevertheless, for the purpose of granting dispensation under 12A of the Act, any examination can only be conducted on the touchstone of when the right to sue arose. Otherwise, no suit for infringement or passing off would ever require any pre-institution mediation or settlement. The section cannot be interpreted in a manner to render the same meaningless or nugatory. Then kindly see, my lord, Yamini Manohar is relied on, held that suits where the urgency was artificially created. So, my lord, artificially created would not bypass the requirements under 12A. Non-furnishing of an explanation or justification, despite having knowledge of the alleged act of infringement or passing off in the facts of this case, is a clear attempt to artificially create urgency. In the absence of any pleadings to justify the delay, there is no question of relying on any supporting evidence at all. Unfortunately, the plaint is merely a cut copy paste job. The plaintiff has not even attempted to proffer any explanation as to what transpired from the date of knowledge that is January 2024, till the date of filing, that is September 2024. My lord, now if this is the finding, my lord, if I put it in question form, my lord, where is this, my lord, how is this gone wrong? Because there is no pleading to that effect. My lord, it's an admitted fact by both the sides on this aspect. My lord, these are my respectful submissions.
Yes, Lord. Kindly have a look at. This is Lord re-arguing the matter without answering what Lordships had asked, Lord, with deepest of risk. Kindly have a
Well,
look.
if he has not answered, he has not answered.
Lord, kindly, Lord, takes Lord. What was Lordship's? Lord, I'll go by the order because my limited answer should be to the points, Lord, 1, 2, 3, because I have argued
Yes.
fully.
Yes. Anything new that he has argued? The two case laws?
Yes, two case law. Lord, what he has to, Lord, contemplation, what Lordship's order, if your Lordship takes his second page. Lord, kindly take the order of 30th.
Yes, you read out,
2025. The point is that if a learned judge dispenses the requirement of a pre-suit mediation contemplated under 12A of the Commercial Act, under what circumstances, if at all, excepting in case of falsity or deception, the learned judge would be justified in revoking the order of dispensation with the requirement of pre-institution mediation. So, Millard, this is the limited window of Jamini Monohar, Millard, which the learned judge has himself, Millard, said, Millard, in the other judgments I showed. Millard, in the Millardship, can take it from me, in the impugned order, there is no finding of Millard falsity of deception. Learned judge's finding, Millard, so-called Millard, say it's an artificial urgency, and Millard, inclusion of, with lot of hesitancy, I say, additional notes, Millard, judgments in the Millard notes on arguments. This is, Millard, cannot be a ground, Millard, for Millard rejecting, Millard, a plaint, Millard, in question. Now, Millard, next point, what was the changed circumstances? That is also a query. The learned counsel is required to address us on the point as what was the changed circumstances which prompted the learned judge to revoke the leave under section 12A of the 2015 Act. So what was the changed circumstances? Because, Millard, in Millard, our High Courts, Millard, if your Lordship knows, Millard, when a plaint is presented, Parkour. Prishti Calcutta 30 para 33 আমি সাইড করছি ভুলে
Yes.
Millard, a leave was granted. There is no Millard order, Millard. Lordship finds an endorsement. Millard, why Millard? Under Chapter 7, Rule 4 of Millard, the original side rules, any special leave granted at the time of presentation and admission of the plaint is endorsed thereof. It's Millard, Chapter 7, Rule 4. Subsequent urgency, Millard, this is what this Millard, some judge, honorable judges follows giving a detailed order at clause 12. Millard, leave under clause 12. Some Millard mayor endorses it. For special leave, Millard, it's Millard, Chapter 7, Rule 4. He has endorsed the leave. There is no order, Millard, to such effect. To go back, I take Millard, Lordship, what Lordship says, one has to presume it from the order of Millard granting the injunction, which records January 2024. So both has to be read together. So it's not Millard, Millard, I say a jurisdictional error, Millard. Because Millard, the honorable judge was within his jurisdiction to grant leave by endorsing behind the back of the plaint under Order 7, Rule 11 of the Millard Code of the original side rules. Now, Millard, so far as the judgment, which Lordship Millard he wanted to place, but Lordship's view was Millard that since Dhanbad fuels you have placed, you need not place the other. He has placed it today, but this was part of the compilation. Now, Millard, kindly have a look at the judgment of Millard, Justice Bhattacharjee Millard, of Millard at page 68, protractive shipping. Millard, kindly have a look at para 17. This is a judgment which is pre-Srishti, Millard. It's a judgment pre-Srishti. It's not a post-Srishti judgment. It's a judgment pre-Srishti. Millard, this 17, the owner shifts to the defendant subsequently to establish the suit did not contemplate urgent relief at the time of institution. The court will examine the case brought by the defendant in considering whether dispensation of the mandate under 12A was wrongly granted. This has been watered down by Dhanbad Fields. I have placed the paragraphs, paragraph 93, holistic reading of the plaint from the standpoint of the plaintiff, keeping in mind the nature of the suit, the subject matter and the relief scheme. Dhanbad Fuels in one paragraph, that is what Dhanbad Fuels play, and Dhanbad Fuels follows Patil Automations, paragraph 93 onwards, where Patil says this is not a suit which contemplated urgent relief and no injunction was filed, no urgency application was filed. What would happen in a case which would consider in a case where urgency is needed, we are not deciding that issue. Which is the judgment which decides the issue? Jamini Mona. Limited window, two cases, falsity and deception from the plaintiff in question. That is not an additional thing given. That is Jamini Manohar restricting it. The limited window open. Limited window doesn't mean that everything is open under the sky. This is the limited exercise while considering a revocation application in the 12A in question. Limited window open. So 17 is squarely hit by Dhanbad Wells. Kindly takes para 18. It is also relevant to state that grant or refusal of relief is not relevant for deciding the issue of urgency. The court's finding in urgency is of paramount importance. This is precisely why the second order dated 19/10/2023 comes into force. So if a second order there must be an order of second order which weighed on the court. Second order dated 19/10/2023 comes into force. That is, some sort of order must be the Honorable Single Judge has passed.
Yes.
Next. The finding of the court for vacating the order of arrest have been dealt with above are not being repeated. Suffice to say that the case sought to be made out by the plaintiff for urgent relief at the time of presentation of plaint was demolished at several levels. What does it mean, Subsequently, the plaintiff could not establish, the urgency in question. Must have been the interim order has been vacated. That is, her specific finding, failed to at a subsequent level. The court specifically found there was no urgency pleaded otherwise shown by the plaintiff. Further, even if urgency requirement discounted, plaintiff's maritime claim could not have travelled with the vessel. Since the claim was restricted to the erstwhile owner of the vessel, the second finding was based on the provision of the Admiralty Act. Now, kindly, takes the judgment, paragraph 25 with my learned friend as 27. The power of the High Court to grant dispensation of requirement under 12A of the Commercial Court Act is on a similar footing and conferred on the Act. The High Court is hence entitled to revoke dispensation granted under 12A. The power to revoke the dispensation granted can be made suo motu without being tethered with an application made by the defendant. I do not dispute it, but the limited window, there is no finding. If there is no finding in an order, in an appeal, if I am challenging that, dehors the finding which is contemplated in Jamini Mona, the limited window, whether that order can be sustained. Now, kindly takes the last part which my learned friend placed, para 40. 4040, page 76.
Yes.
Plaintiff's argument that contemplation of urgency may revive post institution of the sort or even at the stage of trial is without statutory basis. The word used in 12A makes it clear that contemplation of urgency begins and ends at the point of institution, i.e. material point of time when contemplation must fructify to be proved and pleaded for the case of urgency. Hence, allowing the suit to remain in the record despite absence of urgency or contingency of the urgency may arise at a later point of time is patently contrary to mandate of 12A. Now, kindly takes the next one. Moreover, the word urgent relief by the definition means that the relief which the plaintiff seeks at the interim stage and one cannot wait for adjudication affidavits or at the time of trial. I pause here for a moment. I had sought for an urgent relief, though this is not a necessity, my lord, under my lord Dhanbad Fuels. But the learned judge holds that my lord urgent relief sought without waiting for affidavits. Here, my lord, without waiting for affidavits, ex-parte stage I have got an order. Because my lord, subsequent order is recorded in there, my lord, that subsequently in several stages the plaintiff did not prove any urgency. Now, my lord, kindly, my lord, just lordship reads on. Hence, this stands to reason the plaintiff would be under an obligation to explore mediation as an alternative redressal before institution of suit, where the plaintiff does not need such urgent relief. My lord, who will decide this, my lord? It's a contemplation of the plaintiff. That's Dhanbad Fuel, my lord. Unequivocal in, my lord, so many places, not from the standpoint of the defendant, but the standpoint of the plaintiff. Now, my lord, kindly have a look at leave for dispensation of mandate of section way would hence be necessary where the plaintiff cannot afford in terms of time to exhaust the remedy of mediation only after institution of the suit. This, my lord, has been negated by the learned single judge himself, that the window of 3 months is not itself a guiding factor for, my lord, going to mediation. This is negated in the order itself. This is negated by the learned judge, my lord, himself in the earlier order, my lord, of my lord Unique. I argued this point and I lost. That no, this cannot be the ground. That 3 months window is not the guiding factor or the sole factor. Now, my lord, kindly takes, my lord, para 44. I had placed it. The issue before the division bench, my lord, para 44. The issue before the division bench of this court in Gabriel Metal versus Maria such and such was whether first court was right in granting leave to the appellant for dispensation under 12A of the Commercial Court Act, or whether the plaintiff should have been compelled to institute mediation before filing the suit. This judgment, however, does not consider party automation. The view expressed by the Supreme Court in Jamini Manohar would also bind this court in consideration of the 12A of the Commercial Court Act. The same may be said with regard to Ramesh such and such. In that case, court was not confronted with an application by the defendant for revocation and dispensation under 12A. The issue whether the master under the originals has the power to grant 12A of the court. Odisha Slurry Pipeline, SCC Online Calcutta, the word contemplate used under 12A of the Act get emphasis on the pleadings made for making out a case. So, my lord, Gabriel not considered in view of, my lord, Gabriel did not consider party automation and, my lord, Jamini Manohar. But, my lord, Srishti considers Jamini Manohar, paragraph 33 of my lord Srishti. If your lordship takes, my lord, Srishti in question.
Not again.
My lord, it says so. My lord, and my lord, in a trademark matter, if your lordship, my lord, has a trademark act, lordship has a copy, or I hand up, my lord. Kindly have a look at it. Not to be sure, but a copy either. Relief in a suit for infringement and passing off. The relief which a court may grant in a suit for infringement of passing off, referred to under section 134, includes injunction subject to the terms, if any, the court fixes at the option of the plaintiff either damages or an account of profit, together with or consideration with the delivery up and infringing of labels and marks for destruction and erasure. The word of injunction may include an ex parte order of injunction. So the Act provides for an ex parte order of injunction, and in this matters, my lord, it has been, my lord, judicially held, my lord, that delay is not a ground for, my lord, defeating an injunction. My lord, pleadings are there. I, my lord, say, my lord, knowledge is January 2024, my lord. I do not say, my lord, my knowledge is, my lord, something that I have not pleaded knowledge. But it's a recurring cause of action. The parties are before the court. In this context, my lord, I come in urgency because the goods are absolutely identical.
That is all.
If that is so, my lord, I think there was no, in, my lord, in absence of any finding, without any finding of deception and falsehood on my part, or changed circumstances.
Lekho.
Only two new things.
Nothing, no, there can't be.
Hearing is concluded. Stop. Judgment is reserved.
Grateful.
Grateful.
আজকেই পাঠিয়ে দেবে আমার কাছে।
It's a long time Millard read the original side rules. Why the Millard endorsement are there?
Well, that perhaps will not apply. Well, that is the only thing I was going to submit.
Cannot special.
Because of the commercial code set.
Special leave Millard, it's always, it's within the, it's a part of the Millard
But there is a
commercial.
direction, my lord.
Nothing may turn on it, whether endorsement.
But the only thing is, my lord, correct, original side rules perhaps will not apply.
Great. Millard, no, clause 12 is also necessary to be taken. File it under 134. And that was one of my arguments when
But
Trademark Act
again-
Millard came into force.
But it's
Judge
the-
says no.
But 134, my lord, section was in 1999.
I said Millard,
Millard,
clause
12A
12 is
has
not
come
necessary.
2015.
Clause 12 was not
So, my lord,
necessary
then
because
in
you have a.
intellectual property matter, it will be rendered OSHO.
That's what the learned single judge has said.
Yes, my lord.
Now we have to decide whether he was correct or
There's
not.
also a division bench order.
There's a Millard Srishti also subsequently. Why do we go? Lordship lays down
In
the law.
SRMB matter, Justice sends division benches also.
That is not, doesn't take care of Srishti. Grateful. Grateful, Millard, Lordship, for your patience.
Item number 7. Lord, I appear for the respondent in item number 7, my lord.
May it please, my lords. And I'm appearing for the appellant. But I'm praying for an accommodation for 10 days, my lord. Maybe a fortnight. I'll get ready in the matter. I'm not ready in the matter, my lord.
Fair enough. And why are you on the virtual mode?
Lord, I'm in NCLT, my lord. It's very far from High Court.
No, very well. We may be far, but we are not going to hear you virtually. On the next occasion. Remember
Very
that.
well, my lord. Very well, my lord.
On the request made by Mr. Bagh, learned counsel appearing for the appellants, Karo. What kind of a decree is it?
Lord, it's a
Money decree, my lord. Suit for money, which has been
money
dismissed.
decree, my lord, against us. My lord, I'll indicate, my lord, that
No.
the
Next
Against us.
let this matter stand adjourned for a fortnight and be listed again on date the other.
I'm very deeply obliged. my lord. May it only not be on 14th, my lord, of July.
No, it won't be 14th.
14th, it won't be, my lord.
আজকে কত তারিখ?
It's the 7th, my lord, so it will be.
Fortnight.
Very deeply obliged, my lords.
Extremely grateful, my lord.
And you have application item number 2.
The appellants, my lord. My lord, this appeal is from an ex-parte degree, my lord. Now, my lord, there is a section 5 application also, my lord.
Why should we entertain your appeal at all? Go back, apply for recalling, explain your absence if you say it's ex-parte decree. We, as a matter of course, we don't entertain appeals against ex-parte orders or decrees. You have a remedy.
My lord,
And it is not that the appeal is not maintainable. We are not saying that.
my lord.
It is our discretion.
My lord, I completely understand what is.
We'll condone your delay.
My lord.
We'll condone your delay. We'll send him back to the learned single judge if he wants to go.
The thing is that on the point of delay, my lord, I've got decision of Supreme Court which says that the reason shown by them is not sufficient for the delay to be condemned.
Sir, no authority can apply in facts of every case. It is up to the court to decide whether
Of course, my
it is satisfactory or not.
How don't your lordship is
Anyway, we are not allowing the appeal. We are not entertaining the appeal. Why are you creating complications?
it was my duty to.
Yes. How much is the delay?
551 days, my lord.
551 days. That's substantial delay, no doubt. But as we said, we are not entertaining the appeal.
You can simplicity send back, my lord, because
We are not even sending back. We'll say if he is entitled to in law to approach the learned single judge, he'll do so.
that is by way of a separate application. The delay needs not to be condoned, my lord, because he has to file an application.
Unless we condone the delay here, we can't even pass an order on the appeal. Please understand.
So my lord is deciding on the
Deciding on what?
Section 5 application.
Yes, we are allowing the Section 5. But we are not entertaining the appeal.
My lord may only record, my lord, that with regard to section 5, my lord may only allow, and my lord may say that I propose to go back to the learned court below, my lord.
Very well. We'll say so. This is not going to, even if we dismiss Section 5, this will be the effect. You can't prevent him from
Lord, I'm not saying that.
approaching the learned single judge.
Saying that. What I'm
So
saying is,
let this be disposed of. Let this be disposed of. Application to now, jeta condonation. Which one? One or
My lord,
two?
GA1, my lord. My lord, I have
One,
filed a reply, my lord, to their opposition, my lord.
This is an application for condonation of delay in presenting the appeal. Stop. We have heard learned counsel for the parties. If you want to make submission, we will not stop you, sir. But you know our views.
may I just hand over the judgment, my Lord,
Give it.
for my
Give it.
Lord's.
Give it. Give it.
To hear it.
কি একটু আমাকে বলবেন সাইটেশনগুলো অ্যাটলিস্ট দিয়ে দিলেই হবে
My Lord will kindly see para 10.
1 second.
Exactly what is. The stand taken by them is exactly what has been stated in para 10. My Lord kindly sees the reply.
It will be better for you, sir. We understand your client is a public sector company. But just because it's a public sector company or a government department or a government company, there's no reason why it should deserve special treatment. It is better we don't allow the Section 5, but we reserve your liberty to approach the learned single judge.
My lord, may kindly allows my lord why I will tell your lordship because there has been a my lord. I have given reasons in my Section 5 application, my lord. There has been a change of officers also, my lord. In the meantime, my lord, and my lord, if my lord allows me to argue on the point of appeal, my lord, the suit it had an arbitration clause and it had venue in Bokaro, my lord.
We will not hear
My lord, my condoms and my sends back, my lord. I propose myself to get sent back to the trial court, my lord. I propose myself, my lord. My lord, may kindly records my submission, my lord.
My Lord will kindly allow Mr. Sengupta to.
Well, I have detailed in my application, my lord, that there has been an exchange of communications with the present advocate. I have explicitly stated in my Section 5 application, my lord, there has been exchange of communications and why the decree and why the status of the suit court below was not aware to the applicant, my lord. And
Why? Why?
My lord,
you have a law department?
My lord.
You had law officers?
Yes.
My lord.
So?
Well, there was change of officers in the law department, my lord.
Doesn't matter. That is your problem. Doesn't matter.
And my lord,
that is exactly what this judgment says.
My lord, I may not explain I may not put the blame on the advocate, my lord, but we didn't had the my lord.
Sir, you have an option. You have an option of withdrawing this. We'll grant you liberty.
My lord, kindly condones the and propose me to
withdraw it. We will not. We'll dismiss the condonation application. We are giving you this option.
My lord, kindly grants me that liberty then, my lord.
Learned advocate for the appellant seeks leave to withdraw the Section 5 application and the proposed appeal, as he says that his client will approach the learned single judge for recall of the ex-parte decree that the appellant, his client has suffered. Stop. Paragraph. Leave is granted to the appellant / applicant to withdraw the application for condonation of delay and the proposed appeal, as also the proposed stay application, which stand dismissed accordingly. Stop. This will not prevent the appellant from approaching the learned single judge with an appropriate application if it is entitled to do so in law.
My lord, my only notes, my lord, the time spent in filing the appeal to such date, my lord.
Section 14, plead it. Why should we grant you? It is there in the Limitation Act. না এ তো সবই withdraw করে নিচ্ছে।
Appeal from order, item number 8.
It's my application.
My lord, I have a very innocuous prayer. My lord, I'm led by Mr. Jishnu Chaudhary. He's requested, my lord, if it can be kept on next Monday.
I am.
For the respondent?
Yes, my lord, I'm for the respondent.
Oh, Prem Kumar Chaudhary.
Yes, my lord.
Official liquidator.
No.
Gwalior.
Officially.
I'm for the plaintiff and the respondent in the appeal.
Is the OL appearing before her?
My lord, we have intimated the OL, my lord, but
And the OL
OL has filed
submitted
an
to the court.
affidavit, but OL has not appeared yet.
Anyway, if he doesn't appear, we'll have
He
to
has filed
dispose
an
it.
affidavit.
Point is not very
No, my lord.
complicated. Very well. On the request made on behalf of the respondent number 1,
Yes, my lord.
comma, let this matter stand adjourned and be listed again on next Monday.
Yes, my lord. 14th.
तारीखটা দিয়ে দাও। হ্যাঁ, 14. July 14. Which part of the world is he in now?
Beyond EM bypass. Lordships will. That is the at most direction I can suggest.
All right.
Grateful, my lords.
Item number 9.
Lord, I appear for the appellant. My lord, I was addressing, my lord, on a section 37 appeal. I had started my arguments, my lord. I had started my arguments, my lord. My lord had indicated, since we filed our written notes, my lord, I'll only indicate the pages from the written
Yes.
notes. That will be, my lord, cutting the matter short to a large extent, my lord.
Your 34 was dismissed.
34 was dismissed. On petition, appellant petition, appellant.
Yes.
Yes. Lord, we kindly have my written notes. My lord will recall, just to recapitulate, my lord. My lord, the dispute concerns a works contract which was granted by me. I'm the West Bengal Housing Board. I had granted a works contract in favor of the respondent contractor, my lord. certain disputes and differences arose, especially after submission of the final bill by the contractor. My lord, we had, according to the contractor, we had illegally withheld certain amounts from the contractor. The contractor went to arbitration, my lord. The arbitrator was appointed by the housing board, my lord, as per the contractual terms. My lord, this is all prior to 2015. The contract is prior, the award is prior, everything is prior 2015. So the amendment had not carried forward to make the arbitrator ineligible. My lord, the arbitrator was an engineer, my lord, engineer, professional person. He was not a lawyer. My lord, regardless, my lord, the arbitration proceeded. It resulted in an award against us. Several claims were allowed. Also, several claims were disallowed, including our counterclaims. My lord, now the only grounds of challenge, my lord, they're all contractual. My only ground of challenge is, my lord, the award could not have been passed in view of the bar contained in the contractual provisions themselves. That's my short case. My lord.
Entire award could not have been
No.
passed.
Certain heads. The substantial heads I have indicated in my notes. My lord, which specific clauses I'll indicate. My lord, for instance, my lord, claim 1 on the last occasion I was indicating. Claim 1, my lord, was for, my lord, incorrect placement of piles by the contractor. As per the contractual terms, and I'll show the contractual terms, my lord, if an incorrect placement is made, and this is recorded also by the arbitrator, then my client, being the employer, cannot be made liable for the same. If you put a pile in a wrong position, you have to correct it, and you will bear the entire cost of that pile, my lord. I cannot be made liable for the costs incurred by you in placing that corrective measure. That is my short case. That's claim 1. Similarly, for the other claims, my lord, I have indicated the page numbers of the, I've quoted substantial portions of the award. I have underlined the highlighted or the
These
portion
page numbers are of the paper book.
of the paper book, all of the paper book, my lord. The contractual provisions I'll just indicate. If my lord kindly has my note, my lord, summarized it to the
So
best of
your short case is portions of the award, major part of the award,
yes.
is contrary to the contractual terms. Section 28(3).
As it stood prior to 2015 amendment, which says that arbitrator has to decide as per the terms of the contract and not simply consider the terms of the contract. This is again, my lord, this is a case which has to be looked at from a different lens. Today we are in a substantially narrower lens of section.
Amendment of 28(3) came when? Which year? That was also 2015.
That was 2015 or 2019. It was much after my award. After my award. I'll indicate the exact date. Arbitration Act.
Arbitration Act.
I'll indicate.
With effect from 23rd October 2015.
So the 2015 amendment. And my lord, the learned single judge, and this
Your award is dated?
2010, my lord. I'll indicate. 30th September 2010. Much prior. My section 34, in fact, is an
pre-amended
28 has to be considered, my lord. And that apart, my lord, one small legal point, my lord, we'll consider at the end after the merits. The learned single judge has also proceeded on provisions of the amended post-amendment section 34 and has viewed the award, that's my contention, my lord, has viewed the award from a lens post-2015. When the Supreme Court has categorically held that after 2015 amendment, my lord, the scope is much narrower than it was prior. So, my lord, that is a fundamental legal point that I wish to, my lord, argue before, my lord.
So what you are saying is, if an award is pre-2015 and the award is challenged, or the challenge comes up before the learned single judge in 2020, let us say 2020, then it's the unamended 34 that has to be considered.
My lord, because it's a pending proceeding as on that date. 2010, my AP was already filed. My AP was not filed post 2020, my lord. Will kindly consider.
On this, you have any authority?
My lord, I have an authority. My lord, BCCI Kochi Cricket, I'm not carrying it right now, my lord, but then I'll place it before, my lord. I have one judgment of the Honorable Supreme Court which says that after 2015, the scope is much narrower. That I have, my lord. May I just cite that 2022 4 SCC bill?
Is because of those explanations which have come in particularly.
Yes. It's become
no reappreciation of evidence, even if there's erroneous application of law, that won't matter.
Yes. Even if there's a mistake in law, the arbitrator cannot be faulted.
Correct.
All of that makes it much narrower.
Correct.
But I have one judgment of the Honorable Supreme Court, my lord, where this has been observed. My lord, will kindly have a look. Paragraph 12, my lord, will kindly consider. 2022-4. Paragraph 12, my lord. May I just place the paragraph, my lord? Essentially from Placetum E, I am placing. Placetum E, the Arbitration Conciliation Act 2015.
Paragraph?
Paragraph 12, Placetum E.
Yes.
The Arbitration and Conciliation Amendment Act 2015, for short, the 2015 amendment, amended as on 23rd October 2015 inter alia by inserting the explanations to section 34 within brackets 2 of the said act, as well as by inserting 2A of section 34. There is no doubt that the scope of interference by the court became more restrictive with the amendments coming into force. The pre-amendment position with respect to public, the expression in conflict with public policy was enunciated in Sangyong and so on. So my lord, the Supreme Court, that's my fundamental case. My lord. Today, the learned single judge, she's deliberated on the merits of the award. Undoubtedly, I will try to satisfy my lord. But then a fundamental, perhaps error in the judgment is it's been viewed from a different angle, and specific references I'll show from the order as well. Specific references made to 34(2)(a).
If we are with you on this point,
my lord,
then it will be a case for remand.
my lord, that would be one of my prayers as well, my lord. For another reason also, my lord, I had indicated on the last occasion, the learned single judge has considered only 2 of the claims which you had challenged. We had in fact challenged all the claims, but she has deliberated upon and rendered findings in respect of only 2 heads of claim. Though in my written notes, I'll show that from the records, all of them were challenged. So, my lord, I understand that perhaps might not prima facie seem to be a bona fide contention on my client's part, but my lord, will kindly consider my client did not choose to forego any of the claims, and neither was any submission at any point made that I am foregoing the other claims. Perhaps the arguing counsel at that point, I was not there, my lord. I can only speculate, my lord. The entire gamut of the section 34 was.
Did the learned judge record in
Yes,
that the other points have not been pressed?
Yes, my lord, the learned judge has recorded that the arguments have been restricted substantially to these 2.
Then we have to go by that.
I understand.
We have
This
to
is a
go by
point, my lord, I have to, since my client, my lord, this is a point that they insist upon, since the entire award was not perhaps placed properly, my lord. I cannot say anything more, my lord. I cannot say anything more, my lord. That's the only thing I have to point it out to, my lord. My lord, in my note, my lord, I've concentrated on the heads of claim which are specifically contrary to the contractual bars. May I just place that, my lord? I've also set out the portions of the award. My lord, claim 1, if my lord has. Claim 1, my lord, will kindly note this is a claim for payment of piles which were installed by the respondent as a corrective measure, and that's recorded in the award itself. My lord, here the relevant portion is set out. Page 3, if my lord kindly comes to. My lord, we kindly see the findings or the reasons for which the arbitrator allows the claim. Paragraph, page 3, my lord, the underlined portion, if my lord has. In an item rate, may I please, my lord? In an item rate contract with the employer's regular supervision as per applicable usage of construction work, prior to any reinforced concrete work, approval and measurement of location, red setting out in this case, shuttering, red board in this case, and reinforcement, red reinforcement cage and its lowering is again necessary. After approval of the respondent, the claimant completed the work. Then at the same point of time, prior to 8th January 2004, prior to issuing the letter marked as R96, this is 538, I'll also draw my lord's attention to that. In documentary evidence, with pile heads popping up in the ground, discrepancy in the pile cap geometry according to the drawing and according to ground reality in literal sense became probably prominent in some cases, leading to rechecking of the pile positions with reference to the cardinal points in those cases. As a result, pile numbers 1604 to 1622 were installed as a corrective measure, but the respondent at no point of time put the blame on the claimant for the wrongful approval of the 17 locations on their part up to 31st March 2004 up to the installation of 1619 piles. In fact, the respondent had made payment for 1618 piles arrived on 31st March 2004 through ad hoc so and so sometime between 31st March 2004 and 24th August 2004 for reasons not recorded anywhere save and except the abstract of the final bill. The respondent made a complete reversal of the earlier and drafted a final bill for 1604 piles only instead of 1622 as recorded in the measurement books. And the learned single judge will kindly note has relied substantially on these measurement books. So the disputes and so the claim of the respondents in defense against this claim is that the clause of the contract under the subhead setting out, but there is no evidence showing that the respondent at the time of giving approval for the concerned 17 piles points any error in setting out was shown or any instruction was given which was not carried out by the claimant. And surely the respondent, after giving their total approval to setting out at those 17 pile points, then leading and instruction the criminal, it should be claimant to undertake.
Criminal?
No, it will be claimant. That's
The claimant.
it should be claimant. It should be claimant. Claimant to undertake boring at those points and finally formatting, lowering of the reinforced cage and pouring of concrete at those points, thereafter recording in the MBs, and MB is measurement books, making payment for all the piles installed at those points cannot suddenly after a lapse of about 9 to 10 months deduct payment for the 18 piles. These are replacements of the 17 original wrongful installed piles. To say the least, this is a height of violation of natural justice. I don't know how comes is applicable here, Mulad. I therefore accept the claim so and thereafter, Mulad, the claim is allowed. Mulad, sum and substance, Mulad, the arbitrator holds that the piles were wrongfully placed initially. The arbitrator holds that corrective measures were undertaken. The arbitrator holds that we do not intimate them as to the wrongful placement of the original piles, though it is an admitted fact that those were wrongfully placed. That is an admitted fact, and that is the finding of the arbitrator. Thereafter, the arbitrator proceeds on the conduct of the respondent, my client, and the appellant before Muller, to say that I cannot resile from my, if perhaps estoppel is possibly what the arbitrator was trying to say. Since I've already made a representation and caused them to do certain work, I cannot resile, perhaps, though that is not the language used. But Muller, my essential point is, this is again taking all the facts to be true. Though my client's cases were indicated that these were wrongfully placed, as would be evident from the piles. One of the piles were popping up. They're supposed to be underground. Well, that is recorded, which I in the portion I placed. They're popping up out of the ground. So there could be no question of me accepting those wrongful placed piles. Thereafter, I come and I say that you are not entitled to payment of that amount. Because it was an ongoing project, I was making on-account payments, but I cannot deviate from the terms of the contract itself. Now, this, my lord, will kindly take my contentions thereafter. Para 7 at page 4. The aforesaid findings are expressly contrary to the terms of the contract. Here, two clauses are set out. My lord, may I place those clauses? May I take, my lord, to those clauses?
Yes, yes.
My lord, volume 1, my lord, will kindly take. Page 88. Volume 1, page 88, my lord.
Hey.
Huh?
You write Mukhopadhyay or Mukherjee?
Mukhopadhyay.
Mukhopadhyay. We'll come back in 3 minutes.
Piles.
Yes.
Yes. My lord, here, may I just please disclose very quickly, my lord, if the tilt and shift are more than the permissible limit, the concrete is of poor quality, and the load test is unsatisfactory, or there is any defect which, in the opinion of the engineer in charge, will affect the strength or life of the pile will be rejected, and the following or other corrective methods approved by the engineer in charge shall be adopted for the pile in question at the contractor's expense. These are the crucial words which were missed out or not noticed or ignored by the learned arbitrator while arriving at his conclusions. At the contractor's expense. Thereafter, my lord, the corrective measures are, my lord, pointed out. My lord, we kindly note after Roman 2, the last unnumbered paragraph. Against all these, the contractor will not be eligible for any extra payment. The contractor will not be entitled to any extra payment. Thereafter, my lord, setting out is also relevant in this, in respect of this claim. The portions of the piles, may I please, my lord? The portions of the piles are to be set out by the contractor from original points which will be provided by the engineer in charge. The contractor shall be responsible for all errors in setting out and shall rectify the same at his expense to the satisfaction of the engineer in charge. Well, this read with the arbitrator's findings. Well, the arbitrator proceeds on my conduct. Well, what has my client done wrong?
This point was urged before the learned single judge.
Well, it was. Well, the single
The
judge was
order would
no,
reflect
claim
it.
one was not. Claim one was not. But it was substantially indicated in the written notes, my lord. Will kindly allow me to, my lord, place my case, my lord. Then, my lord, if my lord is not satisfied, my lord.
Yes, of course. You can only do your best, Mr. Mukherjee.
This was not, but in my humble submission, my lord, this is a relevant piece of information and rather a vital piece of evidence as well as a contractual clause. It's staring in the face. My client cannot be, perhaps the learned advocate who was appearing then, I cannot say anything, but then the client cannot be burdened, my lord, for a claim which is ex officio contract, contrary to the contract, my lord. Ex officio I'm showing. I'm not showing any documents
Nothing
of mine.
stops your client from accepting it, even if the contract gives your client protection. If you
No, yes, my lord. Now, as to acceptance, the arbitrator, my lord, proceeds on estoppel, my lord. My lord, we kindly bear with me. The arbitrator proceeds on my client's conduct. The arbitrator says, yes, these were wrongfully placed piles, but the engineer in charge of the respondent said you place it as a corrective measure here, here, and here. Thereafter, the claimant proceeds on that. And then we also make payment. We also make payment in respect of those piles in an ad hoc. It's specifically mentioned as an ad hoc payment under a running account bill prior to final bill.
that was part of your counterclaim.
My lord, counterclaim was in respect of delay and non-performance. That was rejected. Separate point, my lord. Separate point. My lord, because my client's case is, I cannot claim that as a counterclaim either. My client's case is simple, that today, if you have placed certain piles wrongfully, you bear the expense for correcting them. And this is as per the contractual terms. And there's a letter, vital letter, which has been referred to by the learned arbitrator. But in my humble submission, my lord, it has not been considered at all while coming to the finding. The arbitrator says, my lord, that wrongful placement of piles was discovered at some point prior to 8th January 2004. I read out the portion of the award, my lord. Prior to 8th January 2004. The arbitrator says that I make payment in March 2004. This is an admitted fact. Payment on an ad hoc basis. Now, that letter of 8th January 2004, the arbitrator refers to R96, but it does not consider it in proper, my lord, as per itself. My lord will kindly, my lord, I have taken, my lord, through the clauses. Now, my lord will kindly take into account, my lord, R96, page 538 of volume 4. This is referred to in the award, but the arbitrator does not appreciate it. My lord will kindly consider this. Volume 4. Now, this is all contemporaneous correspondence.
Have you referred to this 586
Malad,
in your...
there in the award. I'm just referring, Malad.
No, in your written note?
Malad, I have not specifically mentioned it, but it's referred to in the portion that I had read out, which is set out of the award. There R96 is referred. Page 3 of my written notes, Malad, R96 is referred in the award itself. I just want to place that once. Because the point of conduct is coming up, Malad. Even if, Malad, the contract says otherwise. 8 January 2004, this is my client's letter to, Malad, will see the respondent here in the award holder. The construction...
538.
538 of volume 4.
Yes.
Kindly, may I just please the construction and installation of board pile numbers 8 to 6 as well as 8 to 5, I think, Mulad, is completed as reported. That's not relevant. Now I would request you to check up the position of the piles in respect of cardinal points of those buildings. Installation of pile work shall be accepted as completion of pile work if the position of piles are found in order. It is seen that the pile caps number 6 to 8 building has not been cast till date. First, 8 January 2004 till checking, not slow progress of work, not relevant at this stage. We'll take the next paragraph, the last paragraph. You have not yet submitted the designs for pile caps for wide deviation of piles, number so and so and so. What I am relying upon is the first paragraph, the last few words. The pile shall be accepted if found in order. My client makes its position quite clear on 8 January 2004 itself, prior to payment, prior to preparation of the final bill. So the arbitrator's finding that I am stopped because my client had accepted it. My client had said, yes, you go ahead with it. My client had also made ad hoc payment. My lord, is contrary to this piece of evidence where my client says it will be accepted only if found in order.
Yes, but the fact that you made payment,
my lord,
wouldn't that indicate that
my lord, will
you were satisfied?
No, my lord, I'm sorry, my lord, only I would not agree with that, my lord, only because my payment was made on an ad hoc basis during a running account bill. In the final bill, when the work is certified in total, my client found that these piles were as corrective measures for which they are not entitled to any payment. That perhaps would not amount to estoppel on my client from withholding whatever amount or adjusting the amount payable. That's essentially, one more letter, which I've indicated. Malad will kindly just for the sake of reference, Malad need not be bothered with the paper. Page 600 I've referred to in my notes, where I also indicate specifically page 600 is my client's letter, Malad, where I indicate. Will kindly page 600. This is my client's letter, where I specifically indicate that 18 piles were wrongfully placed, and you are to bear the expense for the same. Malad, that there's a highlighted portion in the middle of the page, Malad. That's clause C at page 600 of the same volume. 600, Muller will see. I specifically state 18 piles were not placed in order. You have to correct the same and you will not be able to get payment for the same. So specifically, there's contemporaneous correspondence in that regard. The mere fact of my client releasing some ad hoc payment cannot operate as estoppel on my client. That's my only contention.
When you release ad hoc payments,
yes, ma'am,
do you refer to any particular portion of the work or no? It is just...
Lord, it's as per a first ad hoc payment, that's the 14th RA bill. It's not specific as to per pile. But it's a total number of piles is recorded.
But each RA bill would refer to some work?
Yes.
Right?
Yes, it would. And here it does. It does, Malad. I'm not saying it does. It's an RA bill by which, Malad, I release payment for 1618 piles, but subsequently, Malad, while certifying the final bill, Malad will kindly consider these are underground structures. These are not apparent to the naked eye. The only thing that was seen on inspection was pile caps prodding out of the ground. On that basis, my client writes on 8 January 2004 that acceptance is subject to them being finally found in order. And thereafter, I record in September 2004, these are wrongfully placed. And even as on September 2004, Malad, final bill has not been prepared. September 2004 is still during subsistence of the contract, during work. This is while the work is still going on. So Malad will kindly consider that this cannot be termed as an estoppel. And apart from that, my primary legal point is, Malad, if the contract says that a certain thing has to be done in a certain manner, no conduct of parties can waive the same. My contract specifically says that if wrongful piles are placed, you will bear the cost for them. Specific clause of the contract.
That would apply to a statutory prescription.
Also, my lord,
Nazir Ahmed, but
yes,
in a
my lord, but
contract
also
parties, what is a contract? Agreement between the parties.
yes, my lord.
Parties can't vary it by
It can, parties undoubtedly can vary it, my lord. But here the conduct is not such that amounts to a variation of the terms of the contract. The express terms of the contract are there and they're staring in the face of the claim. My lord. My lord, claim 5. My lord, I hope, my lord, I've been able to at least show that there is a contractual provision and
yes,
it's
yes.
recording. At least that much, my lord, I'll substantiate it by way of judgment, my lord, that the arbitrator had to decide as per the contract. This is not a court. My lord, we kindly appreciate, my lord.
So that section 28.3 is itself very
Yes,
clear.
yes, yes,
Unamended.
yes,
Yes.
yes. Published. My lord, claim 5, my lord, will kindly have now. Claim 5. That's at page 5 of my note. My lord, I've set out, it's a very short discussion. My lord, we'll find that from page 705 to 706 of volume 5. My lord, this is as to additional boring work done for installation of pile due to change in specifications. This is not incorrect placement of piles. This is change in specifications. My lord, volume 5, page 705.
You have set out the entire discussion
Yes,
in the written note.
yes.
Let's read from that.
Yes,
the note. Yes.
Yes. Here, my lord, will kindly see the only ground, I have underlined it, that is the only finding in my reading of that portion of the award, is that the respondent has remained silent into the aspect of change in the minimum pile length. Admittedly, there was a change in specifications, and the arbitrator only proceeds on the point that we have remained silent. Now, my contention here is, my lord, we'll see it's a very short discussion. There's not much there in it. For this, 6 lakhs was awarded, 6,68,000.
The arbitrator was a civil engineer.
Yes, yes. That's why, my lord, even in the prior claim, my lord had noticed his use of the word usage. He proceeds throughout the award, my lord, that's a repeated occurrence. He proceeds throughout on engineering usage, on usages, practice, engineering practice. This seems to me to be right. The award is, in my humble submission, my lord, it's also vitiated on that ground, because that usage, when there is an express contractual provision, a usage cannot override that contractual provision. Especially in the unamended, as has rightly fallen from my lord, it cannot. It was traveling beyond the jurisdiction of the arbitrator. My lord, here my only contention is page 84 is the relevant clause of the contract, which says that any extra cost required for extra length of boring between the existing ground level and the cutoff level would have to be borne by the contractor. My lord, will kindly come to page 84 once.
Hey, volume 1.
Volume 1. My lord.
Yes.
May I place, my lord, that there's a clause towards the end, the last clause on that page, my lord, piles. Here, my lord, the claim is relating to additional boring for additional length of piles. This is the claim. My lord, unless otherwise specified, the rate for pile shall be quoted inclusive of concrete, labor, transport components of the pile rig with other necessary equipment for boring RCC piles, including erection and subsequent dismantling, as well as transporting back from the site after utilization in the works, assuming their basic length as measured from the underside of the piles to the tip, underside of the pile caps to the tip of the piles, in respect of piles as detailed in the particular item of work, in the schedule of approximate quantities. Now, the next line is very crucial, Mulu. The rates for piles shall be inclusive of the extra cost required for the extra length of boring, specific, my lord, extra length of boring between the existing ground level and the cutoff level. This is, my lord, it's a little hazy, it's cutoff level. For any variation in the number of piles required by the engineer in charge, the rate shall be the same as quoted by the tender, and no extra for such variation will be allowed. The rate for piles quoted should also include the cost of testing initial so and so, so and so. My short case is, my lord, here the arbitrator awards a claim on the basis of mathematical calculation. I cannot fault his mathematics. He has said this was the original length of the pile. You have said, or rather the ground level, additional boring was required for an additional length of the pile to between the existing level and the cutoff level. You bear the cost for that additional boring. This is the sum and substance of the claim, my lord. This is expressly contrary to this provision of contract, where, my lord, first and foremost, my lord, we kindly also know this is a contractor who has had to visit the site before undertaking any work, before participation in the tender. He's entered into a commercial transaction with eyes wide open. He has not disputed any of these clauses of the contract. He could have filed a statement of claim challenging these contractual terms. He has chosen not to do so. The arbitrator has not rendered any finding on that. Today, the arbitrator proceeds expressly contrary to these provisions. Now, my lord, a point might arise in the award. This clause is not referred to. Perhaps they might argue that we had never raised this point or we had never placed it. Just to satisfy my lord's conscience, page 375, para 26, my lord, will take a part of my statement of defense. I specifically pointed this clause out. This was before the learned arbitrator. The arbitrator has ignored this clause. Specifically pointed out. May I just place it for my own satisfaction, my lord? Page 375, volume 3, volume 3. 375, para 26. With reference to paragraph so and so of the Muller has page 375.
Yes.
Yes. Lord, page 375, para 26, with reference to paragraph number so and so of the statement of facts and claim, and head number 5, claim number 5, for the sum of rupees so and so, for payment of additional boring for installation of pile due to change in specifications, the respondent states that the claim in the reference is not maintainable. Admittedly, the agency had accepted the measurement recorded in the port cards for all 1604 number of piles. As per the mode of measurement of the piles, the measurement to be recorded from the cutoff level to the bottom point of the file. The rate is inclusive of the portions between the cutoff and existing ground level. In due consideration of the above, the payment has been duly made to the claimant. As such, the claim is not maintainable. Specifically dealt with, the language is exactly the same as the clause of the contract. It is a rate which is inclusive. On claim 5 also, this is my submission, expressly contrary to the terms of the contract. But claim 8, may I come to? Claim 8, my lord, at page 7 of my note. It relates to welding of reinforcement bars in situ RCC board piles wherein the respondent had made spot weld. Well, this is a very substantial claim which has been allowed in favor of the respondent. But may I place the portion of the award? May I just place the award, Malad, or Malad, I'll place it. All the time, Malad, it's at page 710 to 711. I'll just place that. All the time deciding on the claim, I have to consider the following two aspects: whether welding of reinforcement as case as necessary and lowering of reinforcement cage complete as mentioned in item 1 of the price schedule of the contract agreement together with the provisions of the technical specifications of contract agreement. As such, reinforcement used in cast in situ piles shall be made up to, this is a quoted portion, up into the cages sufficiently well wired or spot welded. Mullah, kindly note this terminology: well wired or spot welded to withstand handling without damage means all the intersections of the helical stirrups and main reinforcement are to be spot welded. The arbitrator proceeds to interpret this clause. The next page, my lord. My interpretation of welding reinforcement cage as necessary definitely does not mean all the intersections of the lateral and longitudinal reinforcement are to be spot welded. This is a specific finding. He says that the interpretation of the contract is in my favor. My client's contention, in short, if I can summarize, my client's contention, or rather the claimant said, certain portions of the intersections of the pile work had to be spot welded by them. This is a more expensive work than to be cast in situ. So they had claimed the additional expense incurred by them for that spot welding. This was the claim. Now my client said, I never asked you to spot weld. There was no direction of the engineer in charge. The clause said either in cast situ or spot weld. Why did you do the activity which was more expensive? According to you, which was more expensive, more onerous. I am not entitled to make payment for you for your own activities which you did unilaterally. That is it. Well, here the arbitrator specifically holds that the clause for welding of reinforcement cage as necessary does not necessitate spot welding of every point. Arbitrator holds this, and thereafter, again, well wired or spot welded to withstand handling without damage in the technical specifications does not connote spot welding of all intersections. Considering everything, I state that the rate for item number 1 may be taken as inclusive of run weld of longitudinal reinforcement of the cages, primarily together with the spot welding of a few intersections which may be affected by the handling. Such points where tying of lateral and main reinforcement may be affected by affected with wires being torn. They should be being torn coming off, may be safely considered to be restricted to 5% of the points, approximately 60 points of intersection to a pile of average length. B. The second aspect is the quantum of work done. It may be stated with certainty that the respondent never controverted the work of spot welding at the intersections was done by the claimant. Now, the entire contract in respect of this, the entire contract proceeds on specific approval of the engineer in charge for doing any work. Mere fact of my silence does not entitle them to claim an amount towards something they did without any approval. The claimant stated that at the behest of the respondent, he had to undertake spot welding at all the intersections of all the piles, but the additional was not paid for by the respondent, hence this claim. The respondent took the position that this work of spot welding at intersections was included in item number 1 of the price schedule and hence not payable as additional work. But this letter of 25th June 2004 was written more than 2 months after the work was over, though the prayer seeking payment against the additional work for 400 piles was preferred on so and so. The claimant, after completing work for 1622 piles, again preferred the bill for additional work 14 June 2004 prior to preparation of the final bill. This time the respondent reacted as stated, refer R116. I'll take my lot to that again. Letter from the respondent so and so. In this letter, the respondent made, apart from the work included in item number 1 for 2 additional works, claimant was never instructed to do the tack welding at every intersection. The claimant did not do the tack welding at every intersection. Now this letter marked as R116 by the respondent is full of contradiction. Firstly, if the specifications of item 1 invites welding at all intersections, why there was no instruction from the respondent to spot weld all the intersection points? Secondly, if they felt that there was no necessity for welding of all intersection points, why did they did not keep a record of the number of points spot welded as this was necessary for deriving reduced rate for the work. In short, the document is self-contradictory. Such a document, R116, was written about a month after completion of the total work with its inherent contradictions, hardly weakens the case of the claimant. Hence, I accept the stipulation of the claimant that all intersections were spot welded at the behest of the respondent in absence of any credible documentary evidence to the contrary. Well, there is no documentary evidence to show that I had insisted. The arbitrator says, in the absence of any documentary evidence to the contrary, that is a negative of a negative. It's not the claimant's case there is any documentary evidence whereby I have insisted upon them to spot weld or track weld. I am saying I have never instructed you. The arbitrator holds in absence of any evidence to the contrary, I am allowing this claim. I am saying that they have done spot welding at my behest, that too, when there is no such document. However, I like to state that it was not proper for the claimant to continue work of spot welding all the intersections, even when their letter remained unanswered. C52, my lord, is their letter whereby they seek permission to spot weld, remained unanswered during the month of October 2003. This is particularly so when the claimant knew such spot welding of all intersections is not necessary technically. In such circumstances, I restrict the claim of the welding work in 1425 piles, the piles which were installed up to October 2003 and nothing beyond. Hence, my award to the claim is as under so and so. My lord, the arbitrator himself holds two things in my humble submission. Number one, the arbitrator holds that spot welding is not necessary from his own interpretation of the contract. My lord has seen.
No, spot welding at all intersections.
Correct, my lord. At all intersections. Yes, my lord. Of course. But he does not specify as to which intersections. My lord, his interpretation, may I just again read out, my lord, at page 8, the underlined portion. My interpretation of welding of reinforcement cage as necessary does not mean all intersections of lateral and longitudinal reinforcement are to be spot welded. Coupled with the arbitrator's finding that there is no documentary evidence from either party to show that we had insisted upon spot welding, and also coupled with my own letter whereby I say that you need not have spot welded. Lord, together, my lord, it has to come to a finding. In my humble submission, the finding has to be that this was an unnecessary work which the claimant had done, for which they are not entitled to any additional claim. And apart from that, my lord, the price schedule specifically included all the welding for all the joints. My lord will kindly now just take two pieces of evidence, my lord. Only page 578, my lord will kindly once consider. The document which according to the arbitrator is self-contradictory, 578. That's in volume 4. Volume 4.
R116.
R116. R116. R116, my lord. This is my letter again to the contractor. May I just please, I refer to your letter dated so and so, claiming for extra item of works of tack welding, that is akin to spot welding, my lord. That's just another phrase. Tack welding of reinforcement cage for piling. After careful study, so and so, my lord. Point 1. As per item 2 of the BOQ, as per relevant drawings, there were 6 numbers of vertical rods tied with spiral stirrups, binding with concealed wire, connected wire at every intersection to keep the vertical rods of reinforcement cage in position. You were to fasten joints firmly by connected wire or tack weld, whatever was required and guided as per the provisions of item 1 of the BOQ. That's the price schedule referred to by the arbitrator. Your interpretation of 1 of BOQ is misleading and not at all acceptable. Welding of reinforcement cage as necessary covers tack welding at the intersection within the reinforcement cage as required. You were never instructed by this office to do tack welding at every intersection as claimed by you. My lord will kindly take the previous line and this line. There is no contradiction here. My case is the BOQ required you to do tack welding as required. I am saying that I have never instructed you. How can you be entitled to any claim on the basis of something I have never instructed you to do? If you have done it at your own volition, that is your prerogative. I cannot be made liable for that claim. That is my short case. My lord, the clause also, my lord, will kindly consider it's been set out by the arbitrator. Page 84 is the clause. Page 84 of volume 1. It says exactly what has been set out by the arbitrator, my lord. There's nothing different. I'll just place for my lord's satisfaction. No. No, will give me one.
Mr. Mukhopadhyay, please conclude by 12:45.
So then I'll proceed to the next claim, my lord. This, my lord, is been set out by the learned arbitrator. I need not bother, my lord. Now the next claim, my lord, claim 9. Claim 9.
Yes.
Claim 9, my lord, relates to additional earthwork excavation work by the respondent over and above the contractual quantity, my lord. Page 712 is the relevant portion of the claim, or rather the discussion in the award. Location of pile caps being close, my lord, will kindly let me place the underlined portion at least. My lord, the claimant states they have executed such and such amount of earthwork. Location of pile caps being close, it was not possible to execute strictly according to the drawing without executing shoring work all round. Considering the reuse of planks so and so, apart from the delay, the respondent would have to incur very heavy expenditure for shoring work. The claimant informed about their intention of open excavation. The respondent never disagreed to the claimant's proposal or objected to open excavation. The claimant eligible for extra excavation claim so and so. That's it. This is the totality of the discussion. Again, Mullah will kindly consider here there is no prior approval. There is no prior approval by the respondent for carrying out this extra excavation work. If certain amount of excavation is required, this is a price which is inclusive. What you have to do is inclusive of the quoted price as per the drawing, because Muller will kindly consider the drawing was accepted unconditionally. There was never any dispute as to the drawing that was placed or rather approved by the engineer in charge. To then turn around and say that due to the drawing I had to do XYZ extra work and claim on the basis of that. Now, that perhaps Muller is not a maintainable claim. And the arbitrator throughout for claim 8 and claim 9 proceeds on the premise that my silence or the engineer in charge's silence amounts to approval. That is ex officio contrary to the contract. One provision, Muller, page 78, Muller will kindly take, of volume 1. Volume 1, Muller, page 78. One second. Give me 1 minute. Yes, Muller, clause 16. All works shall be carried out in conformity with the drawings approved by the board. The available drawings ready at present may be seen by the tenderers at the office so and so. The contractor shall have to carry out all works to the detailed drawings which will be prepared and furnished during execution of works from time to time. Well, my drawing was accepted unconditionally. The arbitrator proceeds that as per the drawing, the piles were too close, perhaps certain extra work or rather some extra excavation had to be done. The arbitrator does not consider that the drawings were accepted unconditionally and there could be no additional claim because the entire quoted price on the basis of which the tender was awarded was as per the drawings. And Muller will kindly see the drawing was available even prior to the acceptance of tender. They had seen it, they had accepted it. They cannot now claim additional payment. Whatever price they are entitled to as per the quoted price, but they cannot seek additional payment. This is my only contention.
Tell us one thing.
My-
You have dealt with claim numbers 1, 5, 8, and 9
Yes,
in your written
Yes,
note at least. These were the heads of claim allowed by the arbitrator.
Yes,
Were there other heads of claim which were allowed,
There was,
which you have not challenged?
but also, Mullah, here I must be candid, Mullah, here I have not dealt with my counterclaims because my counterclaim was on delay. The arbitrator summarily rejects. I'll indicate the paragraphs of the award. My only submission there is it is wholly unreasoned.
No, if you want to file a supplementary note on your counterclaim, do it.
Mullah, then we'll
1 page,
grant
2 page, whatever
yes,
it
Mullah,
is.
just a pager, Mullah, because it's really my only contention is it's completely unreasoned. It doesn't go into any discussion at all.
Do it, do it, do it.
Mullah. Claim 9, Mullah, may I just finish, Mullah? I won't take much time, Mullah. Kindly grants me 1 minute. Mullah will kindly take my client's stand. My client's stand, Mullah, at para 30 at page 377. That's a part of my statement of defense in respect of this claim.
Yes.
377. If my lord has a volume 3. Volume 3. para 30. I'll only place the last unnumbered paragraph. I'm sorry.
Yes.
The last unnumbered paragraph, my lord. Para 30 it starts. Firstly, I say it's not maintainable. I'll skip over that, my lord. The last unnumbered paragraph, where necessary, as per drawing for erecting brickwork as shuttering of pile cap, excavation of foundation is required by providing allowance of 500 millimeter all round. In fact, excavation for group of 25-30 piles were not at all necessary. The question of payment of earthwork for individual pile cap has been duly taken into consideration and paid to the claimant is not maintainable. Whatever was due and payable for the pile caps which were as per drawing, we have made payment. Apart from that, not maintainable. But also, this is not, I'm just pointing this out, page 653, para 30 is the claimant's response to this paragraph. Well, there is no denial of this. There is no denial of this. The learned arbitrator proceeds on the basis, Lord has seen it's a short discussion only while allowing this, does not consider the pleadings on record from which my statements in the statement of defense go unchallenged, unopposed. Well, this is again a case of patent illegality insofar as there is evidence or pleadings on record which have been wholly ignored. Well, it would have been one thing if an interpretation was arrived at by the arbitrator. The arbitrator does not. Now, these are my factual submissions. Mallory, grant me just some time to file a supplementary and some judgments.
No, they have not yet argued. So, and also you're relying on some decision in support of the proposition that pre-amendment award has to be examined on the touchstone of pre-amended
section
34. That is important.
Yes.
That's BCCI, is it?
Kochi cricket, my lord. The proceedings, all arbitration proceedings which were prior to the amendment, my lord, will have to be governed by it. And this is an award which is being.
Bring it. When will you come back? Tell us. You need some time to prepare your notes.
I have a small prayer in this matter, my lord. My lord, I have a small prayer in this matter, my lord.
Yes.
Lordship, I have a small prayer in this matter.
Yes, what?
Lordship, in 34, we have filed poor cards, which is not filed here, Lordship. Poor cards, yes, poor cards are filed in section 34 application, but those are not filed here. Those are the part of the award. The entire award is passed based on the poor cards, which shows that the engineer in charge indicated where is to be installed, how is to be installed. So, Lordship, unless those cards, either they can file or the lower court record can be called.
I have not relied upon any of that. I have not even.
No, you may not have. They are relying. So either you file it or let them file it. After all, if they were part of arbitral proceedings, no reason why we should shut it out.
I don't dispute this. Paperbooks have been filed for a substantial period of time. They've never sought.
So why are you taking this point now? Why didn't you file it before?
So, Lordship, when they have relied upon.
When shall we keep it?
If
you want to rely upon anything, bring it. Supply copies to the other side.
Lordship, lower court record can be called for, and a single bench record can be called for. Everything is there.
Very well. When?
Next week, we'll keep it.
And Mr. Banerjee, please make it convenient to be here physically on the next occasion.
I'm leading fever, Lordship. Otherwise, I usually
you are what? You're running temperature.
Yes, Lordship. Almost 102.
Sorry to hear that.
Next week, any day. Next week, any day.
Monday?
You can keep it on Monday.
Monday?
Yes, ma'am. Yes.
Mr. Mukhopadhyay, learned advocate for the appellant, begins his opening submission but does not conclude. Paragraph lists the matter once again on Shamne Sombare date dao, retaining its position. Paragraph, if either of the parties wishes to rely on any additional documents, let the records of the application under Section 34 of the Arbitration and Conciliation Act, 1996, be produced before us on the agenda date. Kaushik, Anino.
Obliged.
I'm deeply obliged. I'm deeply obliged.
Obliged.
এটাতেই রত্নম তো এটা হচ্ছে তো রেস্ট্রিক্টেড হয়ে গেল গ্রাউন্ড গুলো চ্যালেঞ্জের আফটার দি অ্যামেন্ডমেন্ট এই এক্সপ্লেনেশন গুলো আগে ছিল না 2015 এক্সপ্লেনেশন গুলো এলো সেকশন 34 এর অ্যামেন্ডমেন্টটাই তোমায় দেখতে হবে যেখানে আরো ওয়াইডার ছিল মানে গ্রাউন্ড অফ চ্যালেঞ্জ
Lordship, I'm being led by Mr. Nirmalo Das Gupta. He's in court. Nirmalo Das Gupta. He is in court room number 6.
That is nothing can be done. This is 1245 specially fixed. Yes, start.
Lordship, just before Mr. Bhattacharya takes over, in your Lordship's last order, there's possibly an incongruity to the extent that your Lordship has recorded that leave under clause 12 of the letters patent, whereas the subject matter appeal is that leave, the revocation of leave granted under section 12 of the Commercial Codes Act.
Absolutely right.
So just
Absolutely right. যা অর্ডার হবে হবে তার আগে একটা লিখত ভুলে যাব পরে In the order dated June 30, 2025, it has been inadvertently noted that the defendant's application before the learned first court was for revocation of leave under clause 12 of the latest patent. Stop. The fact is that such application was for leave of for revocation of the order of dispensation of the requirement under section 12 capital A of the Commercial Codes Act. এটা রেকর্ড করে রাখুন তারপরে দেখছি তারপর শুনি মামলাটা You are assisting him?
At the very outset, I apologize to your Lordship because an accommodation was sought in the morning for me.
Not in this matter.
No, at item number 1. Well, there's a medical emergency going on at my house. My mother-in-law
No, that's all right.
Diagnosed with cancer and she is being discharged today. She had a tumor removal.
You want to go away now?
No. Now it's sorted out. But may I just first take your Lordships to the Commercial Codes Act. Why the legislature in 13(1) used the term judgment and in 13(2) used the word decree. My lord, the bill was actually introduced in 2009. If your Lordship kindly takes page 5, this was the 188th Law Commission report.
It's the 253rd.
But what has been brought in its present avatar is the 253rd Law Commission report with certain deletions. Now, my lord, will kindly take page 1 of that report, which talks about the 188th report, which was tabled before the Lok Sabha in 2009. But when it went to page 1, my lord, this talks about the 188th Law Commission report. Paragraph 1.3.
Yes.
It was passed by the Lok Sabha, but when it went before the Rajya Sabha, it was thought prudent that it should be sent to the Law Commission for its recommendation. I'll tell your Lordships why. If your Lordship kindly comes to page 3, paragraph 1.6. And 1.7, your Lordship will see the Lok Sabha had introduced this bill. And if your Lordship kindly comes to H, 1.7H. The intent of the legislature in the 183rd Commission was to make all decrees or orders passed by the Commercial Division applicable to the Supreme Court. Then, my lord, your lordship will find C, that it was sent to a select committee and they realized certain disputes because not all high courts have original sites. So, my lord, all these things was discussed threadbare, and my lord, differing pecuniary jurisdictions and all that, and your lordship will kindly see the transfer of pending procedures. Now, your lordship kindly comes to page 24, Roman 2. The original 138 report said all appeals and decrees, there was no appellate division of the commercial courts. And the original bill almost turned Supreme Court into a court of appeal. Now they discussed the basic intendment of this legislature was, India was not considered to be a commercial hub so far as it related to adjudication of disputes expeditiously. That was the real intendment behind the act. Now, my lord will kindly take clause 14 and 15, which would be at pages 69 and 70. This was the bill, but this was not adopted by the parliament. Because I will show that there is a difference between judgment, decree, and order as specified in the CPC. An appeal shall lie only from such orders passed by the commercial courts or commercial court that are specifically enumerated under Order 43 as amended by this Act and Section 37 of the Arbitration and Conciliation Act 1996. This has been decided in Kandla ports, wherein under Section 50 of the Arbitration Act, it is appellable. So the Supreme Court said, no, it is a special statute vis-a-vis the Commercial Courts Act. And in fact, in 2019, to obviate any dispute, a non-obstante clause was introduced in Section 50 of the Arbitration Act. I will come to that. Now, my lord will kindly see what the bill provided for. An appeal shall lie only from such orders passed by commercial division or commercial courts that are specifically enumerated under Order 43. This is to get away with Babulal Khimji. But I will show Babulal Khimji also, when it comes to definition of judgment in CPC, it gives a very constricted meaning. Very constricted meaning. Paragraph 113 of Babulal Khimji. And from no other orders. Orders as defined in CPC does not include decrees. And I will show why the legislature chose the word decree in 13.1 and the term expression judgment in 13.1 and decree in 13.2. Well, all decrees are not judgments. For example, a compromise decree. Under Section 96(3), it's specifically excluded. For example, my lord, an application dismissing a plaint under Order 7, Rule 11B or C, where I don't pay sufficient court duty, stamp duty. The stamp reporter brings it to your lordship that this would be the stamp duty, the court fees payable. Your lordship gives them the right to rectify it within a particular period if they don't. So there is no adjudicatory process. So there is no judgment whatsoever. So those kind of decrees, that's why the legislature, because my lord, I have gone through all the cases, none of the judgments deal with 13.2. It all deals with 13.1. Now, my lord will kindly see Section 15. And this was deleted by the parliament. This was the bill. An appeal shall lie to the commercial courts against every decree of a commercial division or including a judgment. This was not incorporated in the statute. Now, my lord, if I may take your lordship through the Commercial Courts Act. My lord, kindly take section 2, subsection 2. But Babulal Khimji to some extent creates a problem. I will be candid before your lordship. I will show Babulal Khimji also.
One second, Mr. Hey, ye do.
The words and expressions to, I'm sorry, my lord. The words and expression used and not defined in this act, but defined in CPC and Indian Evidence Act shall have the same meaning respectively assigned to them in that code and the act. Act means this act. So this act does not define what is a judgment, what is a decree, what is an order. Now, if I may take your lordship through CPC, the definitions. Judgment is very wide. Now, let's kindly take section 2. Judgment. My lord, section 2, subsection 2 defines what is a decree. Decree means the formal expression of an adjudication, which so far as the court regards, the court expressing it conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit and may be either preliminary or final. It shall be deemed to include rejection of plaint. It's a deeming provision also. So far as rejection of plaint is concerned, either
it was rejected in this case.
Plaint was rejected. Now, under section 12A, for not complying with 12A, but shall not include an adjudication from which an appeal lies as an appeal from an order or dismissal of the suit. We are not concerned with that. Now, my lord will kindly come to the definition of judgment, which is in 2 subsection 9. Judgment means the statement given by the judge of the grounds of decree or order. So a judgment encompasses both a decree and an order. My lord, while disposing of an interlocutory application for injunction, your lordship will give reasons prima facie why an injunction should be granted or not granted. So, my lord, judgment is very wide. The definition of judgment is very wide. Now, my lord will kindly take the definition of order, which is under 2 subsection 14. Order means the formal expression of any decision of a civil court which is not a decree. It specifically excludes decree. Now, if your lordship kindly takes order 20, from where what is the meaning of judgment and decree would be abundantly clear, because CPC does not provide for any appeal against order. It only provides for appeal against order and judgment and decree, not judgment. Judgment is referred to in clause 15 of the letters patent. Now, but my lord will kindly comes to order 20. The court, after the case has been heard, shall, I'm sorry, my lord.
Yes.
Shall pronounce judgment in an open court, either at once or as soon thereafter as may be practicable. And when the judgment is to be pronounced on some future date, the court shall fix a day for that purpose, of which due notice shall be given to the parties or their pleaders. provided that where the judgment is not pronounced at once, every endeavor shall be made by the court to pronounce the judgment within 30 days from the date on which hearing of the case was concluded. But where it is not practicable to do so on the ground of exceptional and extraordinary circumstances of the case, the court shall fix a future date for pronouncement of the judgment, and such day shall not ordinarily be beyond period of 60 days from the date of the hearing of the case was concluded, and due notice of the day so fixed shall be given to the parties. Where a written judgment is to be pronounced, it shall be sufficient if the finding of the courts on each issue and the final order passed in the case are read out, and shall not be necessary for the court to read out the whole judgment. The judgment may be pronounced by dictation in open court to a shorthand writer if the judge is specifically empowered by the High Court in this behalf, provided that where the judgment is pronounced by dictation, the transcript of the judgment so pronounced shall, after making such correction therein as the case may be signed by the judge, bear the date on which it is pronounced and form part of the record. Now, my lord, subsection 3, judgment shall be dated and signed by the judge in open court at the time of pronouncing, and once it is signed, shall not be altered or added. Now, my lord, will kindly see subsection 6, rule 6, I'm sorry, my lord. The decree shall agree with the judgment. So the decree and the judgment cannot be separate. It shall contain the number of the suit, names and description, their addresses and the particulars of the claim, and shall specify clearly the relief granted and or other determination. The decree shall also state the amount of cost incurred in the suit and by whom or out of what property and in what proportion such costs are to be paid. The court may direct the cost payable to one party. My lord, this is not relevant. Now, my lord, in 2002, an amendment is brought into CPC because either it's judgment from appeals, from decrees, which is under section 96, or judgment from orders, which is under order 43. Babulal Khimji expanded the scope so far as the meaning of judgments is concerned in respect to letters patent, because the word judgment does not find expression, an appeal from judgment, in the CPC. But here, the legislature made an amendment in 2002. Your lordship kindly comes to 6A and 6B. This came by way of amendment in 2002. Every endeavor shall be made to ensure that the decree is drawn up as expeditiously as possible. And in any case, within 15 days from the date on which the judgment is pronounced. So, my lord, this is a technical thing which is a procedural aspect where the decree is drawn up. Your lordship delivers the judgment, then directs the department to draw up the decree. But it is basically the judgment which is being appealed against. For example, my lord, certain decrees will not be judgments. For example, my lord, Order 26, Rule 3, as I said, a compromise decree, or your lordship rejecting a plaint under Order 711 B or C, where the plaintiff has not put in a court fees. The stamp register says this is the court fees payable. Your lordship will give them the right. Okay, you have the right to remediate within a particular time. If you don't, your plaint is rejected.
So what is appealed against is the decree.
It is the judgment. It is the judgment. And that's why Commercial Courts Act includes judgment, not decree. And that's why decree is provided in subsection 2. I'll come to that, my lord. Now, my lord, 6B. This is the important amendment which has been brought about. Where the judgment is pronounced, it is to curtail and expedite the process of appeal. The copies of the judgment shall be made available to the parties immediately after pronouncement of the judgment for preferring an appeal on payment of such charges as may be specified. So, CPC by Order 20 Rule 6B in 2002, makes a provision for appeal against judgment. And my lord, why this amendment was brought about, my lord, I'm sorry, I have just one book. My lord, it's on the right-hand side, notes on CPC amendment bill. I could not lay my hands on this because it was pursuant to recommendation of Malimat committee. My lord, if your lordship kindly, I have just kindly marked it. Why this 6B was brought in? It was on the recommendation of the Malimat committee because drawing up of decree, it's a procedural aspect which takes some time. And to expedite it, the Malimat committee recommended that this 6B should be incorporated, and accordingly 6B was incorporated. Now, my lord, if my lord, we'll also look at Order 20, Rule 7. Decree is nothing but a reflection of the judgment. The decree shall bear the day on which the judgment was pronounced and the judge has satisfied himself that the decree has been drawn up in accordance with the judgment. So court has no option. Once a judgment is pronounced, the decree has to follow the judgment. It cannot differ from the judgment. Now, my lord, now looking at the Commercial Courts Act, if your lordship kindly takes the Commercial Courts Act. My lord, the decree is the building and the judgment is the plinth. And there is a reason why they use decision in subsection 2 and judgment in subsection 1. Any person aggrieved by judgment or order, my lord, here judgment would mean a decree. Because judgment includes an order. Judgment includes an order of a commercial court below the level of a district judge may appeal to the commercial appellate court within the period of 60 days from the date of judgment. I don't have to wait for the decree to be drawn up. Any person aggrieved by the judgment or order of a commercial court at the level of a district judge exercising original civil jurisdiction, or as the case may be commercial division of the High Court, may appeal to the commercial court within a period of 60 days. My lord, under the Limitation Act, it is 90 days from the date of the decree. So the intendment of this legislature is speedy disposal. Once I get the decree under Order 20 Rule 6B, I am entitled to file the appeal. I don't have to wait for the decree. Provided, my lord, now the proviso, which has been troubling your lordship, from an appeal shall lie from such orders. Order has been defined under 2 subsection 14 as something which is not a decree. Babulal Khimji expanded the meaning of judgment to include orders which are not appellable under Order 43. So the intendment of this legislature was to curtail Babulal Khimji. Passed by a commercial division that are specifically enumerated under Order 43 of the Code of Civil Procedure. And that's why it has an overriding effect. Now, my lord, this was considered by the Delhi High Court in a case HPL Industries Limited vs QRG Enterprises, reported in 2017 SCC Online 6955. But here, my lord, I would say Justice Badar Ahmed failed to take into consideration Order 20 Rule 6B, which provides for an appeal against judgments. My lord, if your lordship kindly takes, it was my lord, before that, I should also show your lordship. Before the amendment in 2018 to section 13, the scope of appeal was wide because there is no definition of decision in an appeal. So to curtail that, my lord, will kindly take section 13 as it stood in its original form. Any person aggrieved by decision. Decision is very wide and it is not defined either in CPC or anywhere else. Because under 2.2 of the Commercial Courts Act, court has to draw the definitions as ascribed in CPC. So, my lord, to obviate, my lord, any confusion, the legislature in its wisdom removed the word decision. Now, your lordship kindly takes 27 of that report. Now, your lordship will kindly see under section 13, they have removed the word decision.
Yes.
Now, my lord, kindly comes to paragraph 27 of that report of Justice Badar, Division Bench of the Delhi High Court. This is prior to amendment in 2018.
Mr. Bhattacharya, when will it be convenient for you to come back? We are almost.
My lord,
at
would your
recess.
lordship pleasure be that I prepare a note also?
Short one. Yes, yes. So you can
Ably assisted by
Yes, yes.
Tiwari and Mr. Banerjee.
I know both of them.
Mr. Banerjee did not ask for any remuneration, but Mr. Tiwari asked for accompaniments to discuss such
Yes,
convoluted questions of law.
at the senior's expense.
Yes, of course.
When shall you come back? Tell us. Whenever is convenient.
Kindly, because of the
No rush, no rush,
Oh,
no rush.
my lord,
Tell us.
may I come back next Monday?
Yes, next Monday. Likho. Learned amicus curiae, Mr. Bhattacharya, learned senior advocate and amicus curiae, assisted by
Mr. Harsh Tiwari and
Harsh
Siddharth
Tiwari and Mr. Siddharth
Banerjee.
Banerjee, Mr. Siddharth Banerjee, advocates, begins his submission but does not conclude. Paragraph lists this matter once again. Roughly how long we should keep for you? Half an hour?
Half an hour. Huh? 45 minutes, my lord.
12:30. Somebody Monday did the marked 12:30 p.m. ঠিক আছে তো?
Read for me. Shah Babulal Kimji, as a matter of fact, my lord, creates a problem. I'll tell your lordship why. If your lordship kindly takes the CPC. Because Shah Babulal Kimji talks about a final adjudication,
Yes.
which will actually operate as a res judicata. If your lordship kindly takes the CPC for... Your lordship will look at Order 7, Rule 13. Because a rejection of a plaint does not operate as a res judicata. You can file the same suit based on the same cause of action. It does not operate as a res judicata. And Shah Babulal Kimji, paragraph 113, creates this problem. But I will argue, but the intendment of the legislature was not to take away deemed decrees. Otherwise, they would have used it. They have used the word judgment. So, my lord, an Order 7, Rule 11 or an Order 7, Rule 11D, when it is dismissed by your lordship records reasons why the suit from the averments in the plaint is barred by law or why it does not disclose a cause of action. So that would be included within the purview of 13.1.
Very well.
Item number 17, 18, and 19. I am waiting for the appellant, saying for not today. The other side is here, my lord. Not today.
এই দেখে নাও কি বলছেন।
Grateful, my lord. Not today. Thank you.
On judgment item number 1.
You're appearing.
Well, I appear for the appellant.
For the response.
Bank of Baroda?
Yes.
সই করে দাও আগে সই করো করে পরে তুমি শেয়ার করে তারপর সব করতে আনা I quite enjoy the suspense that you go through at the time of.
We have been holding this suspense for about more than 2 months.
Within 3 weeks from the date of order, the appellant was not back is permitted to avoid any minor participant in the act. Authorized the period from the bank also salary not affect because the date of removal with the date of instatement, the date or area salary shall be considered in that.
Deeply.
Lord, may I pray for a brief stay of.
The judgment is delivered, comma. Learned advocate for the appellant prays for stay of operation of the judgment. Stop. Such prayer is considered and refused.
Much.
Deep.
Followed up to the petition.
Appearing on behalf of the respondents, consent.
You are for the appellant.
Yes. Petition.
Single judge's order dismissed.
Deep job.
Can't be, my lord.
Controversial to be mentioned item number 1.
Lord, I appear on behalf of the respondent. Lordship might recall the appeal was dismissed. Appeal preferred against an order of the single judge, my lord, learned single judge, whereby, my lord, their Chapter 13A application was dismissed. Lordships heard the matter, dismissed it, but Lordships have kept it for compliance for the simple reason that an argument was advanced after, my lord, the order was dictated in court, and that has been observed in the order also, that we have not been paying the rent, arrears rent. So Lordship's view was you pay to the registrar and he will deposit it. On that day, Lordship might recall, I submitted that possibly there was a refusal. And my lord, subject to correction, I got an instruction from my client. I have prepared a supplementary affidavit. There was a refusal on the part of the applicant in accepting the rent, which compelled me to deposit the rent to the rent controller. And we have been doing it since, my lord, January 2001. So they can withdraw it from the rent controller. Otherwise, my lord, we will be depositing it again, twice deposit, my lord. Kindly seize this, my lord. And I have informed them also.
Mr. Meghnath Datta is coming.
এটা শুধু compliance এর জন্য। Kindly seize the order dated
Very not possible, he's coming. Male.
একবার দিন একবার। All I have brought it
But
by.
this appeal has not been dismissed.
I think, my lord, Lordship would see, my lord, dismissed. 11 June's order.
Oh, 11 June কোথায় order?
এটা হচ্ছে order দাও। My lord, I have a copy. দুটো copy দাও। Kindly seize this order. Only for compliance. আরেকটা copy। না, আমি
You, Mr. Dotto, then you check up. Because he is filing an affidavit showing that he has been depositing rent with the rent controller since 2001.
2000 after the expiry of the lease.
Whatever it is.
Lease
Whatever
deed,
it
what
is.
I can find from the supplementary affidavit my learned friend has given me, I can find after the lease has expired, they have started depositing the rent.
So without prejudice, you withdraw that.
No, my lord, only one thing, my lord. Since the direction was to deposit with the registrar, my
Yes.
lord, let the registrar take this money from the rent controller, keep it with the registrar, and invest this amount in a fixed deposit term.
Why you don't want to take it?
No, no, let the registrar take
Why
it.
should we burden our officer? If they have deposited with the rent controller, why should we burden our officer unnecessarily?
But then that
She has a lot to do anyway.
the
Or he or
register
she.
can take, there's a department to department,
No.
department can take this.
No, not department to department. It's rent controller. It's not our department.
The rent controller can transfer this amount, my lord.
We say that.
With
What prevents you from withdrawing that without prejudice? We'll say so without prejudice. Henceforth, if you accept without prejudice, they'll pay that amount to you.
They will deposit it with the registrar.
No.
Henceforth.
Why won't you accept? We don't understand.
But that would be interpreted in a different context.
We are saying without prejudice.
Then my lord will protect me, my lord.
Yeah,
Protect.
yes. Hey, Nishu. This appeal was dismissed on June 11, 2025. Stop. After dismissing the appeal, this court had recorded the following. Next, accordingly, the matter has been listed today under the heading to be mentioned, single inverted comma. Paragraph. Mr. Deb, learned senior counsel appearing for the respondents, has filed a supplementary affidavit showing that his clients have been depositing rent/occupational charge in respect of the suit premises with the rent controller since
January 2021 after they refused.
January 2021.
Yes.
January 2021. After, according to the respondents, the appellant refused to accept rent/occupational charge.
Till the month of May 2025.
Stop. It is stated that till the month of May, 2025, rent/occupational charge has been deposited with the rent controller. Paragraph. The appellant will be at liberty to withdraw the amount that is lying with the rent controller without prejudice to its rights and contentions, without prejudice to the appellants. How do we describe he or she or
It's a date.
Without prejudice to the appellants' rights and contentions in this in these proceedings. Stop. Further, it will be open to the appellant to receive monthly occupational charges in respect of the suit premises from the respondents herein till disposal of the suit, without prejudice to its to the appellant's rights and contentions in the suit and all proceedings connected therewith.
Would offer them if they accept, otherwise we will again.
Stop. In the event the defendant, the appellant/plaintiff refuses to accept such occupational charge, the defendants will be at liberty to deposit the same with the rent controller.
Only one line, my lord, is required, my lord. Since my lord is sending me to get the money, my lord, only a direction upon the rent controller. Once I apply, they will give me my money at the earliest possible.
Paragraph.
Otherwise, it will take a...
If the appellant/plaintiff applies to the rent controller for withdrawal of the amount lying deposited on the aforesaid account, the rent controller shall forthwith permit such withdrawal, and in any event within 2 weeks from the date of receipt of the request from the appellant.
And really,
You can set out touch.
Grateful.
Item number 2.
When this same identical matter, your lordship, 22nd May, direct the master to draw the decree, my lord. The order, your lordship, order is at page 120.
2345.
234.
234, my lord.
5.
Then, my lord, 5 also. My lord, 5 of which? No, Kusum Agarwal, my lord.
Yes, there are 4 matters.
My lord.
Kusum versus Binod.
My lord had been pleased to direct, my lord, the master to draw up the decree by considering, my lord, our written submissions. My lord, the master indeed had called us, my lord, but there was one application filed by them, and my lord, that came as an hindrance, my lord, and the decree of 1997 is still not drawn up, my lord.
Your lordship, can you see, I filed an application. Your lordship was pleased to direct the master to draw the decree. So I filed an application under, my lord, Order 32 Rule Chapter 16, my lord, that not being satisfied with the decree to be settled by the master on the 2 grounds, my lord. Application only?
Well, even before the decree was settled, the decree was, my lord, even before it was circulated, my lord, and settled, this application was taken out, my lord, with specific prayer, my lord, that the decree should not be drawn up. Injunction, my lord, may kindly see his prayers. And for recalling of the order that my lords have passed, my lord, on 22nd of May 2025.
to draw up a decree of 22nd May 1997.
Hmm? Yes, you are the defendant.
Yes, I am a respondent too. But I just, my lord, the question, I've been briefed. What I'm trying to submit, my lord, your lordship was to direct the master to draw the decree which should extend cooperation. Master has going to settle the decree, and we have pointed out two things. The description of property is not given there. And she said,
What is eviction decree?
My lord, may I, my lord, submit? My lord, initially a family settlement was entered into between, my lord, the father and the sons. My lord, for that, my lord, there were certain things that were to be done by the father and the sons. Now, the father and the mother were not happy with that settlement, so they filed a suit to call that settlement, my lord, null and void. Therefore, my lord,
This settlement was out of court.
out of court.
Yeah,
So, my lord, that was called the Mittal settlement. I mean to bole di. That was called the Mittal settlement. So now the first suit was filed, my lord, to call that settlement null and void. So at that stage, my lord, no description of property was given. It was only relating to that settlement. Now what happens, my lord? The respondent number 3 here, my lord, they file an application for rejection of the plaint. And my lord, we had filed an application for a joint a receiver. Now, my lord, their application for rejection of plaint was allowed. Our receiver was rejected. So we filed 2 appeals before the Honorable High Court in the division bench, where, my lord, the division bench had been pleased to pass a decree on consent of all parties. My lord, taking into consideration 5 orders, and that was passed by Honorable Justice Ruma Pal and Honorable Justice D.K. Jain on 22nd May 1997. There, my lord, it was all, my lord, written down that these are the properties that are to be given to such and such person, and all other immovable properties would come to me. If required, I have the liberty to put the decree into execution to execute this decree if necessary. The next day, we had applied, my lord, for drawing up of the decree. Since then, my lord, the questions have been raised by the master that we have to reply to certain queries. And this query, my lord, primarily was that the list of properties were not annexed to the plaint. Now, my lord, we came, my lord, this was moved before, my lord, because of the master's query, we had moved before the higher court, this high court once again. There, my lord, Justice S.B. Sinha had been pleased to hold that you cannot add anything that will have a demarcation that was not there in the plaint. So our application was rejected. We went to the Supreme Court. The Supreme Court also held that nothing else is required to be added. Anything that is there is this judgment of Justice Rumapal and D.K. Jain. So we come back. We try and please the master to draw up the decree. They do not. They have the same queries. We move this Honorable High Court before the bench of Honorable Justice Vishwanath Shomadar with Justice Arindam Mukherjee. They have passed an order and a judgment saying if the decree is passed, it must be drawn up, and also gives the liberty to the department to make short recitals and draw up the decree from whatever the consent orders were. Then we go to the master again. The master again raises the same questions, and they want the properties, and this decree cannot be drawn up because there is no list of properties. And we keep on insisting that there are judgments of this court, and you are supposed to draw a decree as to whatever is there in the judgment. Executable, not executable is the subsequent matter. If I have a decree in my favor, I have the right to have the decree in my hand. So, my lord, that is what my application is about. So, my lord had heard it on the first day and directed, my lord, the master to draw up the decree in whatever form it is. The master, before the master, my lord, again, my lord, this same question is being raised that this decree is not executable. You cannot draw up this decree. And my lord, despite winning, my lord, and having an award in my favor, I still don't have a copy of the drawn up decree since 1997. Exactly. May I take your lordships to the judgments, my lord, if required? My lord, I'm led by Mr. Chaudhary.
Chapter.
Have you wouldn't have seen this. There's a report from the master dated 1st of July. She says that, read this, go through this, both of you.
Lord, I have one submission to make.
First, you go through this, Mr. Chaudhary, and then make your submission. Just see what the master says. She says everything is complete now.
Lord, that is exactly 1 minute, 1 minute. Please let me make my submission. I did.
My petition, can you allow me to speak? Why am I made the?
I have made the petition. My learned friend has made a subsequent application. Lordship was hearing mine. Please let me complete. My lord, I am being constrained to say that, my lord, unscrupulous persons are resisting execution of a decree by holding up decree for more than 25 years. Number one. Number two, the decree is of 1997. Now, my lord, assuming for a moment they have any grievance for which an application has been made today, my lord, is it permissible after 25 years?
What is the prayer in the application?
My lord, application is, my lord, I want the drawn up decree. My lord, there are two division benches order. One is, my lord, the decree itself of 1997. And, my lord, the erstwhile master was raising, my lord, defects. And, my lord, lordship will, I have written one paragraph over there, my lord. One relief was, please ask the master to produce the original records. And 2 days, my advocate on record, 1 day was not there, my lord, it was sent to the dead ledger. And, my lord, kindly install, my lord, CCTV cameras as to who visits and what transpires over there. Things are shocking. From 1997, my lord, I have been prevented from the decree being drawn up on one pretext or the other. My lord, once, my lord, all these objections were taken, we took out an application. My lord, kindly see, there is already an order of the division bench of justice.
Chaudhary, now the master says it has been done. Kindly see the report.
Now, my lord, this is
1st July report.
Now, my lord, kindly see, moment they come to know, and in fact, my lord, according to us, the decree is clear. It can be drawn up. I am not saying anything more. The erstwhile personnel, for some reason or the other, my lord, was, my lord, lordship will see the nature of objections.
see the
1
order.
minute, 1 minute, please. And I have, my lord, formulated all the objections and I have stated what our answers are.
You want the decree?
I
Drawn
want
up
the
decree?
decree. Now, my lord, this, when the master, my lord, the present master finds absolutely clear, it is to be drawn up, my lord, to stall that again another application comes.
We will take care of the
Lordship,
application.
kindly, my lord, let the decree be drawn up, my lord. I have been denied the fruits of the decree for 30 years.
Now, have you seen what she says?
Yes, my lord, my lord, kindly see. Learned advocate relied upon 32 of chapter 16 of the original request.
No, last paragraph. Look at the last paragraph of the report.
Yes, my lord, we are agreeable to that.
So there are certain formal defects, it seems.
That is all right, my lord. Let the decree be drawn up.
Now let us see what his objection is. তাও তো একটা application কি করেছেন উনি?
Because I just submit, my lord. My learned friend said.
Let's see what application you have made.
Yes.
We have to allow or dismiss it either way. এটা কোনটা দিচ্ছ? GA5 in APO?
Five, sorry.
In APO 504?
Yes. No, geo number. Yes, ma'am.
শোনো, দুটো অ্যাপিল আছে, বুঝেছো? 504 আর 555. Each অ্যাপিলে দুটো করে GA আছে।
বুঝবো ভাই আমার। ঠিক আছে। কি করবো?
You are the appellant plaintiff.
Yes. My lord, here I am the respondent number 1 applicant.
No, this GA5 in APO 504.
Yes.
Whose application is this?
I'm making an application.
Their application.
Your application.
GA is their application. GA number 6 is my application. I just place it by the.
No, Mr. Roy, please don't confuse us. The petition says it is the petition of the respondent number 1. Who is the respondent number 1?
No. GA5 is their application. I just your lordship, can you allow me? We are both are the respondents. He's the respondent number 3. No, sorry, he's the respondent 1. He filed an application. Last application, this is GA number 5 of 2023 for drawing up the decree.
Who is your client? Binod Agarwal?
Yes.
Who is your client?
My son, Sushil Agarwal.
Sushil
Chaudhary. Sorry.
Right. So this is your application, GA5. GA6 to the GA6 to the. Yes, make your submission in GA6, Mr. Roy.
Can you see what the said correctly? When the suit was filed, it's about a declaration of a private settlements.
Let us just tell you one thing for your client's benefit. If we are not satisfied with your case, huge cost will be imposed, huge. And we are prima facie of the view your client is mela fide, standing in the way of drawing up a decree of this court. The decree may be right, decree may be wrong.
Just point out it that whether decree can be passed without description of the property or not in the decree, in a relief in the form of partition, my lord.
It has been passed. Can or cannot be is not the question, Mr. Roy. Rightly or wrongly has been passed.
Going to be settled.
Going to be settled. The learned master has now said it is almost complete. So let her do it. Cooperate with her. Ask your client not to be too smart. We know how to be smarter.
No, this is our question. Your Lordship, I see. I just press it, then your Lordship kindly.
Very well.
Your Lordship kindly see one thing. My Lord, yes, my language is very clear. They shoot for declaration of a private settlement is bad. So order 7 rule 11 was allowed. Appeal was prepared. In the appeal court, some order was passed, but it is now it is given the nature of partition among the parties. My Lord, after the appeal court's order, your Lordship, can you see one my Lord, notice of the master, then my Lord, can you come to page 86 for a moment? In 1998, after the judgment, master has given a requisition, my Lord. I have page 87 is a relevant page.
How are these relevant anymore in view of the latest 1st July report?
After this, they went to this up to Supreme Court. Yes. Then there's a list of debt. My point is very short. Without including the list of properties, properties, my Lord, decree can be drawn, my Lord. My Lord, I'm pressing my Lord, order 7, rule 3, read order 20, rule 9, my Lord. It's a recovery of the properties, my Lord. This is our only point. We have made out a point with the master two things. Kindly, unless the list of properties is included, can you draw the decree?
Under the decree, what is your obligation? Is there any obligation on you?
I have no obligation, but the decree, but it's a judgment 1997. It was kindly absent. It went up to the Supreme Court, then came
Forget
back.
about it. How does the decree affect you? Does it confer a benefit on you, or does it impose an obligation on you to do something?
But apart from these, when this point was pointed out in 1998.
We are asking a question and we expect you to answer us.
My Lord,
does the decree confer a benefit on you, or the decree impose an obligation on you to do something?
My Lord, it's a mix of, because I can't say that decree because this judgment is there. But I tried to point out only this without list of properties. Can you do it?
You have said that 3 times now. We have noted. We have noted. You don't hammer, it hurts.
Sorry.
It hurts.
You're sorry. You also can see another point. We said you can see the earlier orders of the without list.
Show us Justice Shamadda's order. Where is it?
But because I just
395 of their application.
But if you Lordship kindly, I just place it. But your Lordship kindly see the judgment first.
Which judgment?
Of Justice Rumapal, which is a parent judgment.
No, 395 though. We have a lot of business to attend to.
But page 395 of the GA4 of 2023, page 395.
No, we are looking at GA6 of 2025.
GA6 এ পেজটা বল।
GA6 এ কি একটাই ভলিউম?
GA6 এর লাগানো নেই, পিছনে দে, ইজ ইন অপোজিশন দে। কোথায় আছে? এই তো। এই তো। ভলিউম 3 তে আছে। কি দিন অপোজিশন? পজিশনটাতে
লাগাইনি। তাহলে বলো GA4 এ আছে? হ্যাঁ। GA4 এর পেজ 395 টা দিন জজ সাহেবকে। GA4 of 2023.
That is your application, GA4 of 2023.
ভলিউম 4 এ আছে।
Lordship will see from para 13 onwards, the same ploy was adopted.
The application on which this order was passed, your application.
Yes.
Did you challenge this order of Justice Shramadda's division bench before the Supreme Court?
No.
Then nothing is left to be determined.
I see after this, but our case is very short, my lord.
Your case doesn't survive, Mr. Roy.
My lord, this rules is very much clear, my lord.
The rules have been considered by the division bench, and there's a direction of the division bench to draw up the decree. There is no challenge to this direction, and that is the end of the matter.
I just put in one question, my lord. In a drawing of a decree, if it relates to the recovery of properties or partition, my lord, orders when Rule 3, read with Order 20, Rule 9 can be considered or not? This is why the judgment of our Supreme Court says that should be taken into consideration. This is the only money point, my lord.
This is res judicata, Mr. Roy. We'll not consider this.
But here the judgment, the division bench judgment says you have to call it. But how to call it?
If it's a wrong judgment, go higher up. What stops you?
Judgment is not wrong. Judgment says you have to try. You should try to make it. My lord, after this, who's the master's observation? After this, can is the master observation?
Forget about that. See the master's observation now. 1st July.
My lord, when this observation, my lord, we only point out two things, my lord. I'm sorry, my lord. I'm saying, without descriptive property, it can be done.
Any other point you have?
They have also said descriptive property is required.
Any other point you have, Mr. Roy?
Second point is
4th time you have said without description. Very well.
Sorry, but second, my point is that you also kindly appreciate. In 97, when the judgment was passed, master has said that you have to include the list of properties to draw up the decree. They filed an application under 151, 52, and 53 before the division bench. Division bench says no. This list cannot be included. You cannot change the judgment. They went to the Supreme Court. In the Supreme Court, they have tried to bring the description of property and a list of documents. In the civil appeal, that was dismissed. After 9 years, they filed an application regarding for substitution of one of the parties, and this order was passed. Thereafter, master again said, my lord, and master again said, the list of parties is not there. Now, after that, they have come. The London master should not take into consideration the earlier findings or the queries of the masters or the court of the judgment of the division bench. That's the sit of judgment up to Supreme Court. This is our point only.
Any other point? Issue.
My lord, I am appearing on behalf of the appellant number 1 in this matter. My lord, on last occasion, the order has been passed. On the second last paragraph, it has been mentioned Mr. Ghosh Lanet, senior counsel appearing for the respondent number 4, filed their respective clients' affidavit in opposition. They did not file the opposition. It should be appellant number 1.
Anyway, we are disposing of these applications.
Thank you.
These appeals stand disposed of.
My lord, yes, my lord, only one prayer, my lord. Kindly keep my application pending, my lord, till such time I get the decree. I can't make any further applications. My lord, from 97, my lord, I am being, my lord, just roaming around, my lord. Kindly keep it pending because, my lord, I can't say what sort of conduct, what sort of conduct is taking place. I cannot say it in open court.
Division bench passed the judgment is wrong.
I have said it in para 26. I could not have put it in more civil way.
Number you have come 9 years back after.
GA 6 of 2025, item number 3. Item number 3. This application has been taken out as recently as on June 30, 2025 by the respondent number 2 in this disposed of appeal, praying for the following orders. Page 22 or 23 থেকে ABC দিয়ে দেবে। Paragraph. The decree in question was passed way back on May 22, 1997, more than 28 years ago. Stop. The decree is yet to be drawn up. Stop. Paragraph. এই অর্ডারটা কোথায়? আগের দিনের অর্ডারটা? An application being GA5 of 2023 has been taken out in this appeal by the respondent number 1, praying for diverse reliefs, including a direction on the learned master to draw up the decree immediately. Stop. It is the contention of the respondent number 1 in that application that the respondent number 2 has, with oblique motive, resisted the drawing up and completion of the decree in question, on the specious plea that without a list of properties being furnished, the decree cannot be drawn up.
Description of property.
Without description of properties being furnished, cannot be drawn up. Stop. That application is pending. Stop. Give me that master's report. Today, a report dated July 1, 2025, signed by the learned master and official referee of this court, has been placed before us. Stop. The relevant portion of that report reads as follows. আমি এটা দিয়ে দিচ্ছি লাস্ট দুটো প্যারাগ্রাফ এই রিপোর্টটার। Paragraph. Mr. Roy, learned senior counsel appearing in support of the present application, strenuously argued that the respondent number 1 had filed an application under section 152 of the Code of Civil Procedure before a coordinate bench for including description of the concerned properties in the decree. Stop. That application was turned down by the division bench. Stop. The special leave petition filed against such order by the respondent number 1 herein was dismissed.
It was converted to civil appeal, then dismissed.
Acha, the special leave petition was converted to a civil appeal and then was dismissed. Stop. Therefore, comma, there is no further scope for adding anything to the decree. And without the description, the decree cannot be drawn up. Description of the properties. Description of the properties. Paragraph. We see that there is an order of a division bench of this court passed on an application made by the present respondent number 1. Stop. Where is that order? Which page you said?
395 of GA4.
Stop.
Relevant portion is from para 13.
The relevant portion of that judgment and order dated April 3, 2019, passed in GA number 2285 of 2018, reads as follows. 404, page 404 থেকে 406 আমি ব্র্যাকেট করে দিচ্ছি। প্যারা 13 থেকে 13, শুধু প্যারা 13টাই করলে হবে, ওটাই লম্বা প্যারাগ্রাফ। Paragraph. In view of the aforesaid, comma, the question of any order to restrain the learned master from drawing up or completing the decree cannot and does not arise. Stop. From the records of the case, it appears that the respondent number 2, with oblique motive, has been resisting drawing up of the decree. Stop. The application stands dismissed with costs assessed at rupees 50,000 to be paid to the, you don't want it.
I'll take my
You will take to the state legal authority within a fortnight from date. Stop. Paragraph. The member secretary of the West Bengal member secretary বলে না কি বলে secretary বলে না কেটে দাও। Let a copy of this order be forwarded by our registry to the member secretary of the State Legal Services Authority. Stop. If the cost is not paid within the time period indicated herein, comma, the member secretary will be at liberty to mention the matter before this court. Paragraph. We direct the learned master to draw up and complete the decree in question within a fortnight from the date of communication of this order by the parties or their learned advocates to the learned master. Stop. If any of the parties fails to cooperate with the learned master, comma, the same may be placed before us in the form of a report on the next date when the other connected applications will be listed before us, being বলে ওই যে 2, 4 আর 5. আচ্ছা, 5 is also your application.
No, they have two applications.
So two appeals.
Item 5. Ask your junior.
Yes, yes.
Similar. Same.
You also can include that I submitted relying upon order 7 rule 3 with read with order 20 rule 9.
আচ্ছা, যেখানে মিস্টার রয়ের আর্গুমেন্টটা আছে না, একটা অ্যাড করে দিও। মিস্টার রয় also referred to order 7 rule 3
read with order 20 rule 9 of the service.
read with order
20 rule 9.
20 rule 9 of the Code of Civil Procedure.
One judgment I can refer it, but Supreme Court said list of there's no list of documents they can be drawn.
Stop. He also referred to a judgment of the Honorable Supreme Court in the case of দিয়ে দিচ্ছে জেরক্স কপি দেখে নাও, সাইটেশনটাও দিয়ে দেবে, নামটা দিয়ে সাইটেশনটা, in support of his submission that without a list of properties and or description of properties, comma, a decree for execution of a decree for
the decree.
What kind of decree?
This is decree.
In the Supreme Court, it was what kind of
This
decree?
is specifically act, my lord, but it's regarding recovery of properties, my lord.
A decree for recovery of real property cannot be drawn up. এটা অ্যাড করে দিও ওখানটা। আচ্ছা, তাহলে ওই বিইং যেটা বললাম, লিস্টেড নেক্সট ডেট বললাম লাস্টে, বিইং জাস্ট তুমি এটা করো, এই দুটো দাও, GA 5 of 2023 আর GA 4 of 2023. কারণ GA আজকের item number 5 যেটা, item number 5 will be same order.
My lord, today, my lord, Lordship is taking up GA 5 of 2025.
We just now disposed of GA 6 of 2025.
All right.
5 and 6 are
5 and 6 is
related application.
same.
6 of 2020. This item number.
Yes, so it will be the same order. 6 টা same order করে দিও।
GA6 and GA5. Item 3 are
That item 3 and item 5 will be the same order. Item 3 is GA number 6 of
Correct,
2025.
correct.
Item 5 is GA number 5 of 2025.
Correct. Same order, and your two applications will be listed 2 weeks ahead.
The proposed will settle in Honorable Learned Master will settle. There's a proposed decree to be settled, which is at page 120 to 120. That the parties have to settle.
Settle it, do whatever you like.
Lord, we have indicated ours, they have refused, they took out an application. Kindly keep it pending. Otherwise, my lord, again another mischief.
Mr. Ghosh, it has to be done 28 years. Why? Tell, what's the problem there?
He has given the parties to settle this decree.
Yes.
The orders as part of the sheet.
So do whatever is necessary. It now.
So cost is one application. Cost is only 50 to March it well.
Nah, then 25
Yes.
করে দাও। শোনো, তাহলে এটাই 25, ওটাই 25, একটাই 50,000 কস্ট বলেছিলাম না, কিন্তু এটা only because of Mr. Roy's elocution.
But actually, my lord, cost is not a deterrent. My lord, deterrent has to be something else, my lord. It is, but the things that are percolating is not at all very, my lord, pleasant.
That I can say many things.
GA6 of 2025. It is separate order.
Sir.
1st July. 21st. 21st koro na?
22nd or 23rd is already.
23rd koro. Correct, correct. GA5 হচ্ছে APO 504 আর GA4 হচ্ছে APO 555 দুটোই 1992। হ্যাঁ একই তো আছে।
Number 6.
For the respondent. For the plaintiff, my lord. Previous occasion you ordered for changed cause title, but plaintiff number 1 is unable to reaffirm because of his ill health. He'll come back by 11th of July. So if you could just give 2 weeks time.
I am for the plaintiff's respondents.
You are for the plaintiff.
Yes, plaintiffs. They are the appellant defendants.
Okay.
Yes.
The lordship, I was
This is the third
instructed.
occasion when
You were instructed that you are for the plaintiff, but apparently you are not. So what should we do?
But we had to reaffirm. So
You had to reaffirm,
my plaintiff or appellant had to.
but the plaintiff is not represented by you. Yes, tell us, Mr. What, madam?
they had filed an application before the Honorable Single Bench, praying for filing of the written statement after a delay of 40 years. That application. 40 years, Your Lordship.
40.
Yes, 40. That application got dismissed and challenging that application. They have come before Your Lordships.
But for the appellant, madam, they are for the she's for the appellants.
Yes, she's apparently for.
What is she saying? Something to be affirmed.
The matter first came up for hearing, then they made prayer for substituting 2 of their defendants, which had passed away sometime in 2021. And for time to take out a substitution application. That was about 4 weeks back, Your Lordship.
That was allowed.
Lordship, that was allowed 11 June 2025.
Yes. Now appeal is to be heard.
Lordship, absolutely. After they carry out the amendment, that has, it seems not.
We
done the first appellant.
We directed the department to carry out the amendment.
They were supposed to serve us the copy of the amended application.
That hasn't been done.
Oh, I see. The stay application may be reaffirmed. This is what she's talking about.
Defendants.
She wants time. You want time till 11th of July?
2 weeks time.
2 weeks time.
4 weeks have been given, and if I.
What has happened to the appellants? Why couldn't they reaffirm?
Appellant number 2 has reaffirmed, but appellant number 1, due to his ill health,
What is the illness?
That's some sort of illness.
Then we also don't grant time. We'll dismiss the appeal.
But they'll be back by 11th July. So if you could just.
Then we'll keep it on the 13th of July. 13th is a Sunday, so 14th of July. On the prayer made on behalf of the appellants, let this matter stand adjourned till July 14, 2025. Stop this adjournment. Stop. It is made clear that on the adjourned date, no further time will be granted.
Advance copy to be served to the plaintiff's respondents.
Was title only. So what is that? How does it matter? When did you join the bar?
2023.
83. You attending somebody's chambers? Whose?
Arindam Paul.
Okay.
Thank you, number 7.
Yes, whose appeal is this?
Lordship, this is my application for substitution.
Oh. No.
Lordship, GA2 of 319. APOT 319.
GA2 of 319.
Yes, it can be withdrawn. Lordship, this I will be withdrawing because there is a technical defect in the title. So I would like to withdraw this application.
GA2 of 2025.
Lordship, in APOT 319.
In APOT
319.
Yes. This you will withdraw.
I'll be withdrawing, Your Lordship. There's a technical defect. On the last occasion, it was pointed out, Your Lordship. The defects could not be removed, so we are filing afresh.
Hey, 7 number item test, number 7.
Lordship.
Dekho. Number. Learned counsel for the applicant says that there are certain technical defects in this application for recording the death of the defendant number 1 bracketed choto A and for substitution.
Also before Your Lordship.
And for substitution. Stop. As requested, comma, leave is granted to withdraw this application with liberty to file afresh. No?
Yes, Your Lordship.
GA, it had disposed of, GA2 of 2025. Next one is the new one you have
It's the new one. GA3 in APOT 319.
You are for the respondents? The other respondents.
Lordship, the appellant has passed away on the 15th of March 2025. May he be substituted.
You should lekho.
My Lord, I have a formal objection. My Lord, kindly takes paragraph 12 once. It appears that there are 3 heirs. And my Lord, kindly take prayer E at page number 10. In accordance to the statements, averments made in para 12, this prayer. And my Lord, now kindly take page number 12, the affidavit portion. It seems, my Lord, he's not authorized by the other 2 legal heirs.
Lordship, she is. They have executed a power of attorney in favor of their mother. It is not mentioned here, but it has.
How do we know, Ms. Mukherjee? You should have annexed that.
Lordship, I could have.
I'll add all of them as appellants. Then you should have no objection. All the legal heirs.
All the legal heirs.
Issue. The appellant passed away on
13th of March.
March 13, 2025, during pendency of this appeal. Stop. The present application has been taken. Paragraph. The present application has been taken out by the widow of the appellant for recording the death of the appellant and bringing on record the names of the legal heirs of the appellant oblique defendant number 1 bracketed choto A, comma, namely Prasoon Kumar Bhattacharya. Stop. Paragraph
12, Your Lordship.
We find from the averments made in the petition that the deceased appellant is survived by not only his widow, who is the present applicant, but also two daughters by the name of Akanksha Bhattacharya and Palki Bhattacharya, as mentioned in paragraph 12 of the petition. Namgulo dekhe neben para 12 theke. Stop. Paragraph, we therefore allow this application. Stop. Let the name of the present appellant be struck off from the cause title of the appeal papers, and the names of the present applicant and the two daughters of the deceased appellant, as mentioned above, be substituted in the place and stead thereof. Let the department carry out the necessary amendment to the cause title of the appeal papers within a fortnight from date. Stop. Let copies of the amended cause title be made available to learned advocates for the respondents after the amendment is carried out. Paragraph 8, GA2 disposed of, GA3 of 2025 is accordingly disposed of. Stop. Paragraph lists the appeal under the appropriate hearing. Paper books are ready.
No, Your Lordship. The appeal has not yet been admitted, Your Lordship.
Not
We are on the
yet
admission
admitted.
stage. I tell Your Lordship, this appeal, when it was filed, it appeared before 4 division benches. They were all released one
Appeal
after
from
the
what? Appeal from what?
other. Your Lordship, this is an appeal from an interrogatory application filed in the executing court.
Filed before?
The executing court.
Which is which court? This High Court?
Lordship. Now, Lordship.
No, so then you have it's an intra-court appeal matter of right. Where's the question of admission?
Lordship, there is also a cost imposed upon my client. So we were wanting the appeal to be admitted because the day the appeal came up, the first day, the issue of substitution came up. So until the substitutions are not complete.
কি করবে? ও আচ্ছা। ও তাহলে ঠিকই আছে।
So until the substitutions are not effected, Your Lordship, the appeal could not
let
come.
the appeal be listed under the same heading 3 weeks hence. 3 weeks hence the date.
But matter is the same. This is APOT 320 GA2. Lordship, the same substitution of the appellant by his widow and 3
item number
daughters.
9 is same order.
In this application.
My lord, I have some serious objection. Kindly takes paragraph.
দাও।
Paragraph?
Serious objection.
Lord, this is not permissible, perhaps.
What? Which page?
Your lordship granted liberty to strike out the name, my lord. I see, my lord, how it is done, my lord. No sign of the register, nothing. This is not permissible under chapter 31.
Lordship, this was done because, Your Lordship, what has happened in the original, Lordship will take it up. Lordship, the appeal, the impugned order, this is the cause title. Only thing is, in the impugned order, the name of Shweta Banerjee is struck off by a pen. Lordship will kindly see the original impugned order. ये नहीं appeal का impugned order. The order impugned, Your Lordship, is like this. Memo of appeal देवें APOT. अच्छा. Memo of appeal दाओ तो APOT. Memo of appeal. इधर दाओ. ठीक है. Memo of appeal. Memo of appeal ano ni? Paitado ni.
Yes, that is correct. The impugned order struck out.
Struck out like that.
Yes, my lord, because I tell you, Lord, why. And it takes up.
So, Your Lordship, when we are filing an appeal, we cannot change the cause title. So it has come up as that.
Order take to judgeship. The name of Shweta Banerjee was expunged by the executing court in 2019, and they appeared. The department has carried out the amendment.
2021, not 2021.
I'm sorry. Page number 36.
August 2021 expired.
My lord, my learned senior friend appeared.
I did. But Lordship, this is the copy of the judgment that we got. The certified copy of the judgment.
This amendment was carried out by the department, my lord.
Yes, I'm not a stickler for technicalities. So,
This, my lord, on
what?
the original side rules, my lord. If
What?
it on the appellate side, my lord, I could not have raised the
Yes, original side rule says what?
Chapter 31 says that it must bear the sign of the registrar.
In the original, it is.
If the executing court expunged, deleted the name of this Shweta Banerjee, and if it is, of course, it should have been done by the department. Should have been done by the department.
That is my objection, nothing else.
That is true.
Lordship can allow the substitution, and when they give us a fresh, the amended copy, it can all be incorporated in that. Because Your Lordship, the original certified copy bears the name like this. And in filing an appeal, Your Lordship, we cannot tamper with the cause title.
No, but how was it done after the executing court passed that order? Executing court passed that order.
But the department has not carried it out, and it was
carried out, my lord.
Then it has not come up.
Lordship.
My lord, should I submit, my lord?
Who are you?
Defendant number 1.
Yes.
Item number 15 is the appeal concern.
Yes.
Serial number 15. Exactly what the plaintiff is doing. First of all, this expansion of name from the execution proceeding was done ex-parte.
Who is the plaintiff? You are the plaintiff.
Yes, the plaintiff. Was done ex-parte. The matter was remained assigned before the Honorable Justice Shivkant Prashad. They served us notice that they will be moving before Justice Prashad during the COVID lockdown period. There was no urgency. They moved before Justice Moshumi Bhattacharya. I didn't know. They obtain an order. There is no problem. If one party want to retire from the case, the litigant, I cannot stand in the way. The issue is, the suit is still pending as per the amendment directed to be done in the cost title on 21st June 2019. Read with 19 July 2019, read with 4th September 2019, because plaintiff preferred appeal, taking a plea as if the suit was disposed of, which is not correct according to the record of the court of this honorable court. Now in this suit, Shweta Banerjee's name is there. That your lordship will find from the page number 24 of my item number 15 stay application. Now the confusion is, both before the court as well as before us, that the plaintiff is moving the execution as if he is the sole owner, while Shweta Banerjee, his elder sister, is not party to the execution proceeding, but in this suit. Now in this circumstance also I am facing problem, which is item number 15. Now today, after demise of two brother and sister, from one died on 4th July 24 and other on 13th March 25. Now the plaintiff has taken out amendment application, substitution, but they are not serving the copy of the amended execution petition.
That we are not concerned with that.
Visualize the position. What is?
No, we will not visualize anything which is not before us. We don't want to know. All we are, Shweta Banerjee was being represented before in the proceeding.
They were representing.
You were representing.
My lord, yes, I was representing Shweta Banerjee. There is a will in favor of the present plaintiff, the respondent number 1. He has obtained a probate, and then my lord, Shweta Banerjee's name has been expunged from the execution proceeding. because the right title interest was given to the respondent number 1.
No, but if Shweta Banerjee is a party to the suit,
Yes, the suit has been disposed of in 2007 by
They are unable to show before the trial.
the suit was decreed by consent of the parties in 2007.
where is the decree?
May I show you?
Lordship, that is a big story. Lordship will kindly go into the
No, is there a decree or not? That's all we want to know.
There can be several decrees where the suit has been disposed of because it was directed to amend the cost title, and there are several orders passed in the suit thereafter. Even the report of the commissioner has been accepted in 2011 after 19 December 2007.
What is this?
Yes, it has been decreed. Final decree is there.
Yes. And preliminary decree in final form as per the terms of settlement.
There is a preliminary decree, then there is a final decree.
Preliminary decree is 8 March.
Yes.
The 19 December decree is based on unregistered terms of settlement filed prepared outside the court. Thereafter, it was filed.
That
Honorable
is a-
Justice Mora Sinha was pleased to direct to draw up the decree
Yes.
expeditiously.
Yes.
Not the final decree. But the department
What not the final decree? What do you mean not the final decree?
Takes, my lord.
Lordship kindly sees this. This is the execution petition.
Page number 2.
Lordship kindly sees the execution petition. Lordship kindly sees the execution. Joseph
এটা কি করবো বলতো? এটা হচ্ছে উড়িয়ে দিয়েছে, এক্সিকিউশন থেকে বাদ দিয়ে দিয়েছে। হ্যাঁ, একেবারে। হ্যাঁ, চলো এসো। ওই একই অর্ডার হবে, সিমিলার অর্ডার হবে, খালি একটা জায়গায় নোট রেকর্ড করো অবজেকশনটা। Learned advocate for the plaintiff, respondent plaintiff করো, respondent oblique plaintiff says that the cause title of the present application is defective. Stop. The name of the respondent number 4, comma, Srimati Shweta Banerjee, comma, could not have been struck off in the manner it has been done. Stop. The relevant rules, the relevant provisions of the original side rules of this court have not been followed. Stop. Paragraph, we are of the view that the aforesaid objection, comma, is technical in nature. Stop. The fact remains that the name of Shweta Banerjee was struck off from the array of respondents by the executing court. Stop. Therefore, the cause title of the judgment and order impugned in the present appeal also shows the same deletion. Stop. We find no material irregularity in this regard. Stop. Kore dispose of kore দেবে। হ্যাঁ হ্যাঁ।
I'm grateful, Your Lordship. Lordship, one more respondent has passed away in the meantime. So I'll be moving an application. My learned friend will again come up, but the department has not carried out the change and modification after this. But may I file those applications?
File.
Incorporating those, the
File,
name of the appellant. I'm grateful, Your Lordship.
No, you can't. Unless the department
Lordship carries it out.
carries it out, you cannot.
Yeah.
You can file with the old cost title.
Lordship, then the appellant would be Prashant Bhattacharya, who's not
Correct, but then what to
affirmed
do?
by, I put
Affirmed
it, by his widow.
The
She's
widow
not
has
yet on record.
widow has affirmed this application. How?
Yes. She is affirming, Your Lordship, to be brought on record.
Doesn't matter. She can also affirm or wait for 2 weeks.
I think that will be more safe.
Wait for 2
because
weeks.
this litigation
Otherwise, your
has
learned friend is very strong
Lordship, this is a family dispute.
on original side rules.
Lordship.
He will again.
Family dispute, Lordship. I'm grateful.
Question number 10. I appear for the respondent.
I appear on behalf of the appellant. I was praying for an accommodation today, Your Lordship. 10 and 11. I'm led by
One issue I want to, my lord, just for his, my lord, notice. My lord, the memorandum of appeal only has 500 rupees as the, my lord, stamp. Possibly, my lord, it's an appeal from decree. And my lord, under the two decrees, there are two matters. In the first, it is in excess of 75 lakhs as on date. And against the second, my lord, it is in excess of around 20 lakhs.
So see,
if there is any deficit, Your Lordship, I'll look into it and instruct my advocate on record to make.
There's a lot of deficit, it seems.
Yes, because under the Court Fees Act, my lord, suit and appeal are treated as same for the purpose of computation of
10 teleco. In both the appeals.
Yes, Your Lordship. 10 and 11. Then, Your Lordship, may I?
There are two decrees.
Yes, Your Lordship.
two separate decrees in respect of two separate matters.
10 teleco 11 একই order হবে. Accommodation is paid for on behalf of the appellant. When do you want it?
Lordship, since this court fees also, can it be next week, Your Lordship?
Can be. Just tell us.
Lordship, next week.
Stop. As requested, comma.
14.
Let this matter be listed again on July 14, comma 2026. 25 লিখবেন. Paragraph. In case learned advocate for the respondent says that adequate court fees have not been paid by the appellant. Stop. If there is any deficit in court fees paid by the appellant, comma, the appellant shall be at liberty to put in the balance court fees before the next date.
My lord, it might take some time for him, so lordship.
2 weeks.
21st.
Very well.
21st.
Grateful.
Same order in 11.
11.
You're ready? Take your seat. 5 minutes is left.
5 minutes, the doctor will go take some 2 minutes there.
Just take your seat, Mr. Bandhu. Dao, I have to take it out.
Item number 12.
My lordship, if you have a look at the order dated 3rd of April 2025, on the appearance of the court litigator, there is a senior advocate's name present there. If you may have a look in the memo of appeal, which is on the annexed part. If your lordship may please have a look at the name.
Actually, Mr.
Not be able to assist your lordship actually.
No, madam. Today we'll adjourn the matter. We don't have time. We'll have to rise now. There's a larger bench now. Just যেখানে আছে রেখে দাও এটা যেরকম. Not today করে রেখে দাও. হ্যাঁ. চলো. Overall point of
সেটা কপিটা আমাকে দিলেন না তো দিদি দেখা দিয়েছিলাম enjoy. Lord, can you take my affidavit which I was reading on the other day? Affidavit of Mr. Kunal Ghosh.
Of?
Mr. Kunal Ghosh, I was placing the affidavits. Up to 19, that's when Roman 19, paragraph, page 15, paragraph 19, I placed it. Seven, nine.
কি দিচ্ছ তুমি?
কোন কেসে কোন কেসে? Seven.
Respondent number 8 একটা।
হ্যাঁ, 7 respondent number 8.
হ্যাঁ, তুই এটা নে না।
Mr. Bandyopadhyay, you can start. We'll catch up. We'll catch up. They'll give.
এইটা কি
Lord, after 19, up to 19, I have placed it.
এটা তো তুই কার্ডটা কাকে এটা সাহেবের? Yes, we have.
My Lord, can you come to 20? No. To protect them, a Benami suo motu petition will be filed. That is not acceptable. Now, my lord, 22, kindly read it, my lord. That's another thing. Then I will not read. Notwithstanding the statements made in the aforementioned paragraph, I am tendering my unconditional, unqualified apology for any inadvertent act of mine which may be perceived to lower the majesty, sanctity, and authority of this. I have immense respect and full faith in the judiciary and do not have ill intention to lower the sanctity and majesties of the. I respectfully submit that I hold this honorable court in the highest regards and esteem, and I will always ensure to make all possible efforts to comply with any direction which will be passed by this honorable court. Rest of that, Miller, I am not reading because this is all our repetition. I do not want. Now, Miller, I will take to your lordships the full judgments. Kindly come to Miller first judgment. I wish to show Miller that the first 2005 to CHN. 2005 to CHN 330. তাড়াতাড়ি রেডি করো, নেক্সট পরেরটা এতক্ষণ ধরে টাইম লাগলে হবে না। দাও আমি দাও। কে তিনটে দিতে হবে? This is my lord, Kollol Go Thakurta and another versus Biman Basu, Chairman, Left Front, West Bengal. At the top, your lordships will find reversed in Biman Basu versus Kollol Go Thakurta. Why I am citing, my lord, I will show how this court has proceeded in a suo motu contempt application. That is the reason. And with great respect to your lordships, my lord, that kindly do not. I'm just saying that your lordship is also following that proceeding. Kindly come to paragraph 11. The contempt petition has two petitioners, one Sri Kollol Go Thakurta, and advocate of this court, and Sri Horace Swansto Bollab, a citizen. In the said petition, the allegations against Sri Basu are that in respect of the said order, an appeal has been filed before this court and the said appeal was pending. Despite the fact that the appeal is pending, Mr. Basu held an emergent meeting on 4th October 2023, along with other left front partners, are decided on a strategy to violate the said order, along with other left front partners, and decided on a strategy to violate the said order, and told the press that on 8th October, which is weekday, a mass convention will be held at Mahajati Sadan to protest against the said order. It was also stated that Sri Basu declared before the press and the electronic media that he will flout the restriction imposed by the said order, and also asked all the important organizations which are showing allegiance to the left front for holding procession and demonstrations and defy the said order of this court. This statement of Sri Basu was reported in almost all the leading newspapers of the city on so and also on subsequent date. It was also stated that Sri Basu declared that he would organize procession from the College Street to Rani Raspberry Avenue on weekdays in violation of the said order. And Sri Basu commented that the learned judge who passed the said order did not understand the spirit of Calcutta and such people should quiet the city. Sri Basu is stated to have drawn a parallel between the agitation over the Rowlatt Act during the independence struggles and the agitation over the said order, and also say a go back slogan can be raised against the said learned judge. It is also alleged when Sri Basu so and similar. Then Miller, kindly come to paragraph 33. Not 33 is required, Miller, 43 kindly come. In a 3 judges bench of the Supreme Court, in 3 judges bench of the Supreme Court in the case of Sukhdev Singh versus Honorable Chief Justice Teja Singh, Year 54 Supreme Court, this was recognized by the Apex Court by holding that power of High Court to initiate proceeding for contempt and punish whenever necessary is special jurisdiction, which is inherent to all courts of record. Dealing with the question in paragraph 34 of the report, the learned judge held that the High Court could deal with the contempt allegation content summarily and adopt its own procedure. All that is necessary is that procedure should be fair and the contemptor is made aware about the charge made against him and given a reasonable opportunity to defend himself. This principle has been repeated by the Honorable Supreme Court subsequently also in so and so, so and so, so and so. Paragraph 11 and at page 162 of the report, it has been reiterated that the High Court's power for punishment of contempt has been preserved by Constitution and thereby are also inherent in a court of records. The learned has that only carved on such power is proceeding. Let kindly leave then kindly come to paragraph 50. In SK Sarkar 50, in SK Sarkar, the Supreme Court clarified that the object of prescribing procedural modes of taking cognizance under Section 15 of the said Act is to safeguard the valuable time of the High Court and Supreme Court for being wasted by the filing of frivolous contempt petition. The learned judge also made it clear that if the High Court is prima facie satisfied that the information received by it, even on the basis of a petition about the commission of contempt, is not a frivolous one, and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence action against the contemptors. It has, however, been made clear that such mode of taking cognizance suo motu is to be resorted sparingly, and frequent use of this may render the safeguard odious. But it cannot be said that the High Court cannot take suo motu cognizance of criminal contempt just because a petition has been filed without the written consent of the Advocate General, even if the petition discloses prima facie materials for taking cognizance. Then, my lord, kindly come to paragraph 63.
Sorry, Mr. Bandyopadhyay, which paragraph?
Paragraph 63, my lord. I am showing this all. Comments which are outspoken, frank, and candid may be fair, but good faith must be writ large all over them. The reason behind such comments should show whether they are in good faith. But when good faith and reason disappear, and any person or of ordinary prudence reading the comments discussed in them as attempt to defy the denigrate the judicial process in a matter which is sub judice, as in this case, the comments cease to be fair. This court, however, does not say that fair criticism of a judgment is not permissible. This can always to be done, as justice is not a cloistered virtue, and it's because of such fair criticism that justice delivery system will also improve. A person may not like an order of the court, so and so may not leave this. Then kindly come to paragraph 68. Understandably, the definition of criminal contempt under section 2C has been worded in generic terms and very broadly with expression like tends to scandalize, tends to interfere in clause 1, 2, and 3 of section 2C of clauses, concludes with the expression in any other manner. Expression of every wide import have thus been deliberately used to define what is criminal contempt, as it may take various forms. Supreme Court also accepted the same, so where it was laid down that the definition of criminal contempt is wide enough to include any act by any person which would tend to interfere with the administration of justice or would lower the authority of the court, so and so. Then kindly come to Miller, paragraph 78. In this country, everyone has to live and function under certain constitutional imperatives, and one of such imperatives is to accept and submit to the authorities of court. Under a constitutional government, such authority has to rest in some institution which are manned by judges. In the absence of constitutional dispensation, where there will be chaos, therefore the verdict of the court is to be respected and accepted, as has been said, not necessarily by the authority of its reason, but always by reason of its authority. Then, my lord, this judgment has been reversed. I will show that. 2010 8 SSA, page 673. Thank you. Kindly come to Miller.
Just an academic question. What is the maximum amount of fine that can be imposed under the contempt? 2000 still? Or has it been increased?
I am checking it.
6 months there.
কত আছে এটা? Fine. দেখেন, just I'm checking it.
Yes, yes.
In the meantime, let me kindly come to paragraph 6. The respondent in this appeal moved a কত? 2000. Or with both. The respondents in this appeal moved a contempt petition in the High Court on 30th October 2003 with a prayer to initiate appropriate contempt proceeding against the appellant for making deliberate and willful derogatory, defamatory and filthy statements against Justice Amitabh Lala, which are widely published in the newspaper and electronics media. In this petition, the respondents pleaded that the derogatory, defamatory and contumated statement and remarks to answer. For the purpose that he filed a petition. Here, affidavit. Nothing. Distinction, nomenclature is not the substantive things. Now, 7. A division bench of the Calcutta High Court, vide its order dated 17th October 2003, passed the following order. Hard. After hearing Mr. Ali Learned Counsel moving this petition and perusing the issue, Bortman dated, we are of the view that a rule be issued. Rule is made returnable on 7th November 2003. This court, however, makes it clear the records of this case may be placed before the Honorable the Chief Justice for assignment of this rule. For hearing before any bench of this Honorable the Chief Justice may think fit. Therefore, paragraph 7. After hearing Learned moving this petition, what important factor is moving. Here, affidavits were moved. Mentioned. I will read later to order. And the issue, we are the view. Then paragraph 8. This order was followed by a rule requiring the appellant hearing to show cause why he should not be committed to prison or otherwise penalized or dealt with making deliberate and willful derogatory, defamatory and filthy statements against the sitting judge of this court, Honorable Justice Lala, as well as making such derogatory, defamatory, filthy language remarks and statements in front of transfer of the press, electronic media and open meeting regarding the order dated 29th September to the passed by the Justice Lala. The appellant was required to be personally present on 7th November before the court. The appellant was accordingly service transfer. Paragraph 8. Then, my lord, kindly come to paragraph 15. In the present case, we are concerned with the criminal content. Criminal content is defined in section 2C. The contempt of courts against the criminal content means the publication. And a definition has been given. 16. In case of criminal content, when other than a content referred to in section 14, the manner of taking cognizance has been provided for in section 15 of the Act. This section interior provides that the action for contempt may be taken by the Supreme Court or the High Court on its own motion or a motion made by the Advocate General or any other person with the consent in writing of the Advocate General. Then, my lord, kindly come to paragraph 23. Yeah, please. 70. The question that arises in the present case is whether the High Court can entertain a contempt petition filed by a private person without the consent in writing of the Advocate General. For determination of this issue, it will be relevant to note that the observation of the Channel Committee, whose recommendations were taken into consideration for enacting the Act, the committee observed. In the case of a criminal content not being contempt committed in the face of the court, we are of the opinion that it would lighten the burden of the court without in any way interfering with the sanity of the administration of justice. If action is taken on a motion by some other agency, such a question officer would give considerable assurance to the individual charged and the public at large. Indeed, some high courts have already made rules for the association of the Advocate General in some category or cases at this. The Advocate General may also move the court not only on his own motion but also at the instance of the court. In S.K. Sarkar vs. Binay Mishra, this court approvingly referred to the recommendation of the committee and observed if the High Court acts on information derived from its own sources, such as formal perusal of the records of a subordinate court or on a reading of a newspaper, or hearing public speech without there being reference from the subordinate court or the advocate general, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved, not being the Advocate General, can the High Court refuse to entertain the same on the ground that it has been made without the consent in writing of the Advocate General? It appears to us that the High Court has in such a situation a discretion to refuse to entertain the petition or to take cognizance on its own motion on the basis of the information supplied to it in that petition. If the petitioner is a responsible member of a legal profession, it may act suo motu, more so if the petitioner advocate, as in this case 34, should act suo motu. The whole object of prescribing these procedural modes of taking cognizance in section 15 is to safeguard the valuable time of the High Court of the Supreme Court for being wasted by frivolous complaints of contempt of court. If the High Court is prima facie satisfied that the information received by it regarding the commission of contempt of subordinate court is not frivolous, and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence and proceeding against the contemners. However, this mode of taking suo motu cognizance of contempt of subordinate court should be resorted to sparingly where the contempt concern is of a grave and serious nature. Frequent use of the suo motu power on the information furnished by an incompetent petition may render this procedural safeguard provision subsequent to the OTS. In such cases, the High Court may be well advised to avail of the advice and assistance of the Advocate General before initiating proceedings. In State of Kerala versus MS Mani, this court said the requirement of consent of the Advocate General, Attorney General, Solicitor, where any person other than the said law officer makes motion in the case of a criminal contempt in a High Court or Supreme Court, as the case may be, is not a mere formality. It has a salutary purpose. The said law officers, being the highest law officers at the level of the state and center, as also the officers of the court, are vitally interested in the purity of the administration of justice and preserving the dignity of the court. They are expected to examine whether the amendments in the proposed motion of a criminal contempt are made vindicating public interest or personal vendetta, and accord to decline consent postulated in the said provision. Further cases found to be vexatious, malicious, or motivated by personal vendetta and not in public interest will get filtered at that level. If a motion of criminal contempt in the High Court or Supreme Court is not accompanied by the written consent of the aforementioned law officer, the very purpose of the requirement of prior consent will be frustrated. For a valid motion, compliance with the requirement of Section 15 of the Act is mandatory. A motion under Section 15 is not conformity with the provision of Section 15 is not maintainable. In MS Mani, the consent of the learned Attorney General was obtained after filing of the contempt petition. This court held that motion to take action against this respondent therein was not made with the consent of the learned Attorney General or Solicitor General, therefore is incompetent. This court observed subsequent obtaining of the consent in our view does not cure the initial defect so as to convert the incompetent motion into a maintainable petition. In PN Duda, etc., Millard, this is all have said up to Millard paragraph 23. Bal Thakare's case also Millard is considered. Paragraph 24. The High Court in the present case, rested in its conclusion relying on averments made in the petition stating that even a suo motu contempt proceeding may be initiated at the instance of the petition on going through the newspaper. But it noted that there is no prayer in the contempt petition filed by the respondent to initiate suo motu proceeding. We are unable to sustain the finding of the High Court in this regard, for the same is not supported by any material available on record. The order 37 and the rule issued in clear and categorical terms reflects that the law was set in motion exclusively based on the averments made in the petition and the affidavit of the verification filed in support of the petition and the arguments of the counsel. There is nothing on record suggesting that the contents of the petition were treated as information placed before the court for initiating the contempt proceeding suo motu by the court. The contents of the petition of the respondents, their affidavit of verification dated 13th October, the exhibit annexed to the said petition, and the arguments of the counsel alone constituted the foundation based on which the law was set in motion. And before your Lordship's court, my lord, if I have seen the video that the several senior counsels have argued, and on the very first day they insisted for issuance of a rule. Then your Lordship said, no, we will ask for the affidavit. Vigorously, the honored senior counsels have argued. Your Lordship can remember. Therefore, it is a case of, well, I wanted to make it, not by the High Court. I am reading. The order there is nothing on record suggests that the contents of the petition were treated as informed placed before the court for initiating a content suo motu by the court. The contents of the petition of the response, their affidavit, verification of the response, the exhibit, and the arguments of the counsel constitute the foundation based on which the law was set on mission. The petition itself is not styled as any piece of information that was placed before the court for court's consideration. It is not a case where the High Court refused to entertain the petition and took cognizance on its own motion on the basis of the information supplied to it in the petition. The record does not bear any such proceedings of the court. Had it been so, the respondent would have been nowhere in the picture. Here the respondents are all in the picture. Petitioners are on the picture. All are fighting. Last day also said, that's the reason I said, kindly pass an order, then I will give it. Give the affidavit. It is true that any person may move the High Court for initiating proceeding for criminal contempt by placing the facts constituting the commission of criminal contempt to the notice of the court. But once those facts are placed before the court, it becomes a matter between the court and the contemptor. But such person filing an application of petition does not become a complaint or petitioner in the proceeding. His duty ends with the facts being placed before the court. The court may, in appropriate case, in its discretion, require the private party or litigant moving the court to render assistance during the course for the proceeding. It has not been done. Your Lordships have not invited them to render assistance. On their own, they are arguing the matter, trying to establish the contempt. Your Lordships have never, from any order, I have seen that your Lordships have sought for assistance. Then, a contempt is a matter between the court and the alleged contemptor. Any person who moves the machinery of the court for contempt only brings to the notice of the court certain facts constituting contempt of court. After furnishing such information, he may still assist the court, but it must always be borne in mind that in a contempt there are only two parties, namely the court and the contemptor. Thus, the person bringing the facts constituting contempt to the notice of the court can never be a party to the lease, nor can join the proceeding as a petitioner. Similarly, is the view taken by this court. Your Lordship's order will show that they are the petitioner. Your Lordship's order will show that they are the petitioner. That's all right. Order will prove the charge. On the very first day, your Lordships are treating them as a petitioner. Next. Then come paragraph 28. In the case in hand, it is evident from the record that the respondents were continued to be shown as the petitioners in the contempt case before the High Court and participated throughout as if they were prosecuting the appellant. There is no order reflecting that the court, having taken note on the information made before it initiated suo motu proceeding on the basis of such information, furnished and required the respondents only to assist the court till the disposal of the matter. On the contrary, the respondents are shown in the petitioners in the contempt case before the High Court. It is thus clear it is the respondents who initiated the proceeding and constituted the same, but without the written consent of the Advocate General, as is required in law. The proceeding therefore are clearly not maintainable. 29. In what manner the suo motu power may be exercised in appropriate cases dealt with by this court in J.R. Parasar versus Prashant Bhushan, in which it is observed, in any event, the power to act suo motu in matters which otherwise require the Attorney General to initiate proceeding or at least give the consent must be exercised rarely. Courts normally reserve this exercise to cases where it is either derives information from its own sources, such as from a perusal of the records or on a reading of a report or in a newspaper or hearing the public speech or documents to speak for itself. Otherwise, subsection 1 of section 15 might be rendered odious. Then 30, while dealing with the importance of the procedure for taking cognizance of criminal contempt, other than a contempt referred to in section 14 of the court in Baltakare, observe the decision in Duda's case was seen and appreciated in the light of what we have noticed here in respect of contempt petition and the powers of the Chief Justice. It would be clear that the same prescribe the procedure to be followed by High Court to ensure smooth working and streamlining of such contempt action, which are intended to be taken up by the court suo motu on its own motion. These directions have no effect of curtailing or denuding the power of the High Court. It is also to be borne in mind that the frequent use of suo motu power on the basis of information furnished in a contempt petition otherwise incompetent under section 15 of the Act may render the procedural safeguards of the Advocate General concerned nugatory. We are of the view that the directions given is legal and valid. Paragraph 31. In exercise of the conferred by section 23 of the Contempt of the Constitution of India and other enabling powers in that behalf, the High Court of Calcutta made the rules to regulate the proceedings for contempt of itself or of a court subordinate to it under this Act. The rule are known as the Calcutta High Court Contempt of Court Rule 9. These rules inter alia provide that proceeding in a criminal contempt may be initiated A, on its own motion by the High Court under section 15 or the on its motion founded on a petition so and so, or C on a motion founded so and so, so and so. Consent of a writing of the Advocate General under section 15 or like this is there. Now, but point which I have argued that the Chief Justice, that contempt, suo motu contempt has to be initiated by judicial order, not by an administrative order. And the rule can be issued by the bench which is having the determination, and only rule can be assigned. These are not argued and decided. Rather, if I have checked up the judgments, first time it is being argued. Initially, which I argued. That is the first point. Now, paragraph 34. In the present case, petitioner one before the High Court is a practicing advocate and argued the case in person. Here is that even the senior lawyers are arguing. Bar library has come. All lawyers are coming, arguing. So far as petitioner number 2 is concerned, he was represented by more than one lawyer. We have meticulously examined the contempt petition in which there was no prayer for taking into suo motu action. The proceeding before the High Court was initiated by the respondent by filing contempt petition under section 15. This petition was vigorously pursued and argued as a private petition. From the material available, this is the important point. Whether it is a private or not, like a private petition.
Mr. Bandyopadhyay, can we ask a question to you?
Yes, madam.
I mean, without going into the merits of the allegations, definitely you have your point on that. Now, suppose in a case where there is an allegation against, in your case, against an admitted person who is the spokesperson of the ruling party. Now, there, the Advocate General, consent of the Advocate General, undoubtedly Advocate General is supposed to be an independent functionary, constitutional functionary. But at the end of the day, Mr. Bandyopadhyay, the Advocate General is the representative of the state, which is governed by a ruling party in the parliamentary system. Now, whether if one of the alleged contemners is the admitted spokesperson of a ruling party, whether the consent of the Advocate General, the prerequisite of that is diluted somewhat.
But would your lordship in that case undermine the office of the Advocate General? There are judges who are in the political parties.
Judges don't represent the political party.
The judges,
Advocate General is representative of the state.
Excuse me, mindset. There are judges, before being elevated, they were in the political parties. Supporters of the political parties.
Maybe.
Then in that case, when he becomes judge, do I expect that the judge will, shall I take it, the judge will decide the matter on a political ground?
No, Mr. Bandyopadhyay, there is a difference here. Advocate General is supposed to represent the state.
Represent the state, how can your lordships can come to this conclusion that Advocate General will act in terms of the ruling party? This is an aspersion. Sorry, my lord. The high status constitutional post. If your lordships think no, Advocate General will not give permission, Because the Advocate General is appointed by the state and state is ruling party.
Mr. Bandyopadhyay, my brother did not mean in this case. It's a general academic question that. Yes.
Forget about this.
Yeah.
No.
Yeah.
He said
This proposition.
Trinamool Congress spokesperson said that. That's the reason I'm saying.
Yes.
Manoj, the moment, let me take it, Vinod. Chief Election Commissioner was the Secretary of the Cooperative Department. 1 month, 1 year before he appeared before us in standing committee. Whatever the Home Minister is saying, he is doing that. When he has Chief Election Commissioner, then they will act on the in terms of the government.
No, there's a difference between what was and is, Mr. Bandyopadhyay. Advocate General is the representative of the state in the court. That remains.
Do your lordships have come to anywhere, any findings, any materials that the Advocate General is acting in violation of law? That would be too wide to, that in that case, with great respect, we will undermine the Advocate General. That is not expected.
Which is a valid answer, Mr. Bandyopadhyay, to our question.
We cannot undermine. Yes. And Duda's case, it has been held. If the Advocate General, Attorney General doesn't give the permission, judicial review is there, amenable. Even it is rejected, judicial review is amenable. P.N. Duda's case. Advocate General action is also under judicial review in such an administrative case.
All right.
When there is a safeguard, judicial review is there. Why not? You will not go to the Advocate General. If the Advocate General pass order on merits, that's a subject to judicial review.
That's a sufficient answer, sir. You can proceed.
জানি আমি ভাই 1988 judgment আমার প্রথম contempt judgment পড়া. First judgment I read, that Juda, he was a law minister. Read this criminal contempt first in 1988. Therefore, I know that. And that time he used to read every line. Beautiful days of life. With this capital, we are continuing now. Nonetheless, in the present case, petition number 1 before the High Court is a practicing advocate and argued with this person. So as petition number 2, he was represented by more than one lawyer. We have meticulously examined the contempt petition in which there was no prayer for taking suo motu action against the appellant. The proceeding before the High Courts were initiated by the respondent by filing contempt under section 15. The petition was legally produced and argued a private petition from so and so. Therefore, my submission is there. Leave aside Advocate General consent. This is not a valid contempt. This is a private motion approved by the Honorable Chief Justice in his administrative capacity.
Very short point, what you are saying then, this is not a suo motu contempt proceeding. It is at the instance of private parties. That would not be maintainable without the prior consent of the Advocate General.
Now, therefore, point is there, Milord. If the Chief Justice would have taken cognizance on the basis of any information, news or video, then I would not have argued these points. And that too in the judicial side, not in administrative side. Let's read it, Milord. The relates to CLB so-and-so filed with the leave of this Honorable Court, the Chief Justice, Honorable Justice Soitali Chatterjee, thus on 28th April to the. Therefore, High Court, Chief Justice Court granted leave to file the affidavits. Therefore, it is not an information to the Chief Justice. Both the affidavits are related to the acts of obstruction of justice, intimation, advocate, scandalization of the court, and interference to and so, and hence praying for taking up the matters as suo motu proceeding for criminal contempt. Who is under the both the affidavits are filed in Rajasthan? The matters are mostly humbly placed before Lordship for appropriate order. This is the Samrat Gupta, officer on special duty of this Honorable Chief. Then the matter was mentioned before the courtroom number 1. Today, by several learned who are informed in their submission that the incidents which occurred on
Swanson is a clear interference to the administrative justice and a threat meted out to the judiciary and the learned members of the bar. Video clipping was shown to us in which it was seen that one person was stamping the photograph of the honorable judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appeared that prima facie clear that the person was mentioning about the names of the honorable judges present and past. There were also a mention about order passed by the honorable Swanson. The matter was mentioned. Why the Chief Justice did not pass any order in court? I would not have argued this much. I do not understand. If a matter is mentioned for bench having a determination, why that bench would not take the cognizance of the matter? And thereafter it was taken in the administrative side. This is not known procedure of law. Court, my lord, in your lordship judicial capacity is granting leave. Matter is being mentioned, take up the matter in the list. And discretion is there that when the matter will be taken up, not taken up. I am not on that. Then why in an administrative side? This is unknown procedure, my lord. Then on that day, if the rule was issued and thereafter it was assigned to your lordships, then I would not have argued all these points. I have placed. Now, my lord, from the affidavit I have shown to your lordships that I am not connected with this matter. My lord, I have some difficulties. This 4:18, I have to rush. I have another 45 minutes.
Yes,
I have promised. I have missed one matter in 12:30. It's a very kindly just
next Monday, same time.
Yes. If I cannot come, my lord, I will do it virtually. That will Lord kindly permit me. If I cannot come, I
No, tell us when will you be here? We'll give you that day.
Thursday to already the time here.
21st July.
Yesterday that 2 o'clock happened now. Then the all places is today. Last Friday. This is whole. Once it.
17 তারিখ আনতে দাদা
17 তারিখ তুই রাজি আছিস?
আমার কোনো অসুবিধা নেই
17 my lord kindly. Another half an hour, so I will finish it. I'll finish it.
ওই সেম আগের অর্ডারটা দেখে নিও মিস্টার কল্যাণ বন্দ্যোপাধ্যায় লার্নেড
17 the best
senior advocate representing
I will take another 20 minutes.
The respondent number 8 in CRLCP 7 of 2025 resumes his argument but does not conclude. বুঝেছো একই order. Next, list the matter once again on July 17, 2025, marked 3:30 p.m.
Grateful, my lord. Only one indulgence may I seek, my lord. Mr. Bandyopadhyay has relied upon certain writ petitions in his affidavit, my lord. Certain writ petition numbers have been relied upon. Yes, Mr. In the affidavit filed by the alleged contender number 8, my lord, I have requested my advocate on record, my lord, to, my lord, disclose the prayer portions as well as, my lord, I have them, my lord. If I can file them, if the court gives us leave, my lord, we can make a compilation, file it for the convenience of the court, and I will
refer to
have.
You fully
I will. We will.
matter. I don't have any objection.
Give advocate.
Yes, certainly.
You fully contest the matter. I have no objection. I want that you fully contest.
Your plane will leave. Go.
No, not plane. I want bail matter. I have
Bail,
to argue.
bail.
then thereafter plane.
Very well. Thanks.
Sorry, my lord. Kindly excuse me.
No, sure.
A pleasure.
Sure.